And I will look to my team as soon as you're able, if you would please bring the court reporter and both, once we have both, up to panelist status. And good morning, everyone else. We'll get started once we have the court reporter all set and ready to go.
I'm ready to go, ma'am.
Great, thank you. Welcome. All right, with that, I will go ahead and get started with introductions this morning. Good morning. It is April 9th. I am Nicole Kinsey, presiding hearing officer for the Administrative Hearings Office of the State Water Resources Control Board. This is the evidentiary hearing on the pending petitions for change of water right permits 16478, 16479, 16481, and 16482 of the Department of Water Resources for the proposed Delta Conveyance project. I am conducting this hearing in accordance with the July 31st notice of public hearing and subsequent amendments. We are conducting this hearing this morning on the Zoom webinar platform. If you're planning on actively participating today, please do log into the Zoom webinar using the individual link that was sent to you by Zoom. If you are having any technical difficulties today, please contact us at the email address of dcp-wr-petition@waterboards.ca.gov. AHO staff are monitoring that inbox and can help you out or let me know. The hearing is being broadcast live on the AHO YouTube channel. If you are not planning to participate actively today, please do use the YouTube channel for viewing the hearing rather than logging into the Zoom platform. Both the audio and video of this hearing are being recorded, and we will post files of this recording in the FTP folder for this proceeding, and the YouTube recording will also be available on the AHO YouTube webpage. We will take breaks today, as has been our usual practice, and we will have a lunch break as well and a hard stop at 5 p.m. I'm going to call for appearances as we did yesterday. That seemed to work, be much more efficient than going through everything now. So, and please remind me if I forget. But with the first time speaking today, I will ask you to we will promote you, if that's the right word, up to panelists, so you can come on camera, introduce yourself, and then proceed with whatever it is you have to say. As is our usual practice, Ms. Mullen will be handling the screen sharing of exhibits today and moving on of slides for those witnesses who, well, I guess today we're not expecting any new direct testimony, so that's not an issue. And then for cross-examining attorneys or representatives, you are welcome to ask Ms. Mullen directly to bring up a particular exhibit. In terms of the order of proceeding for today, my understanding of where we left off was with our panel 5 witnesses, Mr. Murdoch, Ms. Buchholz, and Mr. Volk. And we were partway through cross-examination by Mr. Brodsky. And my list is, we have Mr. Brodsky, Ms. Tabor, Mr. Cho, Ms. Meserve, Mr. Reese, and then possibly Ms. Desjardins and Mr. Moore. And of course, if I missed anyone, you can let me know. But that's the general order that I have noted down for the day. And then I did want to note, hopefully, I think our goal should be to finish with panel 5 today. And if we are able to do that, I think we can take April, is that 14th off calendar, because we won't be starting panel 2 until the 17th. So that can be our goal for today, and I can give you a date back. And with that, I'm going to stop talking and I will look to the room. I see we have some hands up. If we would, please, if we can bring Mr. Cho on video, and we will start there. I'm looking at my team to promote you up to panelist. And Mr. Cho, you're welcome to come on screen and introduce yourself.
Thank you. Good morning, Ms. Kenzie. Austin Cho for North Delta Water Agency and Reclamation Districts 999, 2060, and 2068. I just wanted to note that I spoke with Ms. Tabor last evening, and she agreed to accommodate a scheduling issue I have so that I will be going ahead of her.
Great. Thank you for letting me know. And thank you for working that out amongst yourselves. I appreciate that.
Thank you.
Good morning, Mr. Cho.
Good morning.
And let's please bring up as a panelist, Ms. Desjardins. And you're welcome to come on camera and introduce yourself.
Hello, Deirdre Desjardins, California Water Research, and I wanted to say I could have up to an hour. I'm going to pay close attention to what other cross-examiners ask. I know there's quite a bit of cross-examination, and I'll try to make it non-repetitive, non-duplicative. I also noticed I had accidentally uploaded the first document I uploaded did not have DDJ-001 in front of it, and there was no way to delete it. So I uploaded another document that had the same document that had DDJ-001 as a prefix to the exhibit. And I noticed unfortunately only that the hearing staff had made the duplicate exhibit DDJ-004. And unfortunately, I only noticed that after I had uploaded 3 exhibits to the FTP folder. Starting with DDJ-004. So there are now 2 DDJ-004s, and I have no way of deleting the second one. And I'm wondering if we could strike out on the exhibit list the DDJ-004 that's a duplicate of DDJ-001 and put so it doesn't get too complicated.
Thank you. Thank you for explaining that. I think we can do that. It sounds like we need to identify the DDJ-004 that is identical to 001, and we will remove that one.
Okay, that would be very helpful. Thank you so much.
Thank you. Are there any other comments or procedural matters we should address before we move on? Ms. Carroll, you're welcome to come on camera.
Thank you, Hearing Officer Kinsey. This is Ann Carroll for DWR. I am not in the room with our witnesses or the other attorneys this morning, so I apologize if we have any duplicative objections or any issues with the audio. I'm unwell today. I'm trying to keep everybody else well. I did want to bring up a couple of requests. One is I was hoping that we could have a hard stop at 4:30 today due to a flight for one of our witnesses.
Yes.
Unfortunately, thank
you. I understand that. Yeah,
we don't want them to miss their plane.
4:30.
And then this might be contrary to what you just said of finishing today, but just based on the pace of cross, we were concerned about the number of hearing days, and we're wondering if additional days in May could be identified in the event that they are needed.
Let's talk about this. And it is something I was planning to think about once we finish, where we are after our 3 days. I think what would be particularly helpful is, and I don't have it in front of me, is that your panel 3, there was one panel who was particularly, I think, limited on the May days. And if there is a date or days that would work for that panel, I would appreciate DWR's proposal for what dates might work best.
Absolutely. We do have their availability in May, so we'll send that to the email list.
Great. Thank you very much. I appreciate that.
Yeah, and then one last administrative request is with the uploading of the cross exhibits, we noticed that the file names match the exhibit numbers, but there's no identification on the document itself, and that might assist with when we have to print them or if we need them in the future. So if we could have the exhibits actually identified on the face of the document, we'd appreciate that.
We will work on that internally. I think we should be able, and this is for the cross exhibits particularly.
Yes.
And
then
maybe something
anticipation.
Yeah,
Oops.
we'll see if we can do it. I'm not sure if we can do it, but it should be easy enough to stamp it on there. So we'll figure that out. Thank you, Ms. Carroll.
Yes, and in anticipation of the case in chief for the protestants, that would be our request. Thank you.
Right. Thank you very much. And if we can please bring up Mr. Brodsky to panelist. And Mr. Brodsky, you're welcome to come on camera and introduce yourself.
Thank you. Good morning, Michael Brodsky on behalf of Save the California Delta Alliance and the Hood Community Council. And as to Ms. Carroll's comment about the exhibits not being marked, I did neglect to put my markings on the actual face of the exhibit as I ordinarily do, and I apologize for that. And I will mark those in the future before I submit them.
Thank you, Mr. Brodsky. I appreciate that. Are there any, and you can stay with us because you're up next, but I'll look to the attendees. Is there anyone else who has procedural comments or questions? Oh, let's bring up, while you're thinking about that, if we can please bring up Ms. Morris, who I see is listed here separately as a panelist, to introduce herself, and then we'll move to Mr. Krieger and grant you both audio privileges. And Ms. Morris, you're welcome to come on camera.
Good morning, Stephanie Morris for the Department of Water Resources.
Thank you. Good morning. And then Mr. Krieger, please. If we can bring Mr. Krieger up. And if you don't mind raising your hand, Mr. Krieger, that helps us. You jump to the top. Thank you. And you're welcome to come on camera.
Good morning, Hearing Officer Kenzie Miles Krieger for State Water Contractors.
Thank you. Good morning. And with those introductions, is there anyone else who has comments this morning? All right, then with that, I believe we can bring in, I assume the Birds Landing conference room is where our witnesses are. So let's bring up Birds Landing as a. Is that
That is
right?
correct.
Sure. Okay.
Hearing Officer Kinsey, that's just the conference room. Normally we put Trey Beckman, but that's how we sign into that. So it's the same setup as the previous days. But
Understood. Thank you.
apologize for forgetting to rename it.
No, it's a lovely name. And I see we have Mr. Murdoch. Mr. Murdoch, you're welcome to come on camera and introduce yourself. Oh, we need to promote Mr. Murdoch. I'm sorry. We can bring Mr. Murdoch up as the panelist. Welcome, Ms. Buchholz. And Mr. Volk.
Morning.
Welcome. We have all three of our witnesses. Good morning to all of you. And we have Mr. Brodsky, and we have Ms. Carroll and others. Ms. Morris, yes.
Sorry, I think we might have some sound issues for Ms. Buchholz and Mr. Murdoch. So can we do a sound test? Apologies, the headphones are finicky.
Thank you. No problem. Maybe we'll start with Ms. Buchholz. I think it's not on. Is there the magic button isn't working? No, it's still not
Is
coming
it still
through.
not working?
Oh, there we go. No, now it's off. It's not.
I think we have Ms. Buchholz. Maybe we could try Mr. Murdoch.
Mr. Murdoch,
Yes.
barely.
How about now?
That's great.
Okay, thank you.
Thank you. And Mr. Volk, should we test yours?
Can you hear me?
Yes, quite well. And Ms. Buchholz, did we have you? Did we?
Let's try this
Yeah,
again.
that sounds great. I think
Okay.
we have full audio. With that, I will turn this panel over to you, Mr. Brodsky, for more questions.
Thank you. I just want to briefly thank Ms. Mullen. I know I'm jumping back and forth between a bunch of different documents quickly, and you're doing a great job. Thank you. And then if we could begin with Mr. Volk. Good morning, Mr. Volk.
Good morning.
And so in your testimony, you say that you participated in the preparation of the EIR noise chapter, right?
That's correct.
Okay. And the steps in the process for preparing the EIR, including the noise chapter, include DWR preparing a draft EIR. Are you familiar with that?
Yes, ICF participated in preparation of the draft EIR,
Okay.
DWR, yes.
Thank you. And then a following step is that DWR receives comments from the public on the draft DIR. Are you familiar with that?
Yes,
And then the following step is the DWR considers those comments. You're familiar with that?
yes,
And then finally, where DWR decides it's appropriate, DWR makes revisions to the EIR based on information it learns from the comments, correct?
yes.
Okay. And thank you very much. So my question to you is, in your preparation of the noise chapters, did you consider public comments on the EIR in your work?
Yes, I reviewed several comments. I don't know exactly how many, but yeah.
Okay. Did you consider the EIR comments received from the Hood Community Council?
Objection, relevance.
Overruled.
I don't recall specifically.
Maybe we can bring it up and see if it refreshes your recollection. So that would be the Hood errata dated 7/11/24 at PDF page 60.
Is Hood what is it? Is it an exhibit?
It's in the protest folder, and they're arranged by date. If you go down to 7/11/24, there's a document titled Hood Notice of Errata. We were looking at that yesterday.
Yesterday. Yes, thank you.
A lot of documents. And there we are at page 60. I don't know if you can see it there. So this is titled Comment on Delta Conveyance Project Draft Environmental Impact Report, dated December 14, 2022. And then it begins, we're writing on behalf of the people of the small town of Hood, California, to ask that the intakes near Hood be moved away. Does this refresh your recollection as to whether or not you considered this comment?
I don't remember seeing this comment. I know that the comments were reviewed at ICF, and if there was a issue specific to noise, it was assigned to me. So there was a large team working on the comment response.
Okay.
Um,
And then if we could go to PDF page 64. It says there, attached is our town's declaration of protest signed by the entire community. So that was attached to these comments. I'd like to go to that. That would be at PDF page 25 on this same document. And this is the declaration of protest, notifying people that we object, condemn, and impose the harm being visited upon our community, etc. Do you remember seeing this part?
Hold on, let's just pause for a moment. Thank you, Mr. Brodsky.
Sure.
Ms. Morris, did you have an
I'm
interjection?
sorry, I don't know what happened. I do have an objection as to relevance, but I didn't raise my hand to do that. So yeah, I do object to this line of questioning. Mr. Volk's already answered that he doesn't, unless it was a noise related. Plus, we haven't established that this was actually attached to the comments. It's in PDF page 25 of a document that was a further along PDF. So I guess I object to foundation as well.
Okay, well,
Overruled. And go ahead, Mr. Brodsky.
and so just the question was, do you recall considering this part of the comment in your work on the EIR?
I don't recall the specific comment, but I do recall receiving comments of this nature in terms of general concerns about noise during construction. So I think I would have responded to comment addressing these types of concerns.
How did you respond?
I don't recall specifically. I would have to review my response.
Okay. All right. And I just like to point out that this comment is expressing very strong opposition to the project. And then I'd like to go to exhibit HCC 25. So yesterday you talked about this FTA impact, noise and vibration impact assessment manual, in particular with regard to the setting of an 80 dBA criteria that you considered. Is that correct?
Well, partially. I can see this slide is an earlier edition of the manual from 2006.
Okay, correct.
The version I used was from 2018, but
Okay.
it's an updated version of this.
Okay. But you did reference an 80 dBA criteria from that 2018 version, correct?
Yes, that's correct, yes.
Okay. And then if we could go to the next page.
Objection, relevance. This isn't the document that our witness relied upon.
I am concerned about that, Mr. Brodsky, with the version difference. Let's see what your question is, but
Okay,
that is
so Mike, you just scroll down a little further. There in that next to last bullet point. It says, community views, this manual provides the methodology to make an objective assessment of the need for noise mitigation. However, the views of the community cannot be overlooked. So with regard to, without regard to which version it is, just as to that statement coming from the FTA, do you think that's reasonable to say that the views of the community cannot be overlooked?
Oh, yes, I do. And I believe that in setting thresholds, in setting the thresholds that we've been discussing, the DWR set threshold of 60 decibels during the day and 50 decibels at night, that does address what we understand as concerns about noise in a quieter setting, the rural setting of the Delta. So we did set a lower limit than described in the Federal Transit Administration guidance, because the views of the community, this is something that we understand the rural setting, and we've heard the concerns being raised over time. So our thresholds account for those concerns.
And the threshold was 60 dBA, was that right?
Yes, 60 dBA during the day, yeah.
And isn't that DWR's standard threshold? That it's their procedure to use that on every project?
Objection, relevance.
Overruled.
Well, I don't know the answer to that, but I do know that it was used on another project, another DWR project, and we used that as a guide for determining the threshold for, and it's in the, we describe it in the EIR where that comes from. It was from another DWR report. But I don't know the extent that it was used for another project that I'm not aware.
Okay. I'll have to go back and find it and ask you about it, but I believe that it says that's DWR's standard threshold. So I'd like to then show you a mitigation measure that was used on a similar project, on another tunnel project, and ask your views if that might be reasonable and feasible to use it here. And that would be HCC EX15. This is just a very brief description that on the Caldecott Tunnel Project, another tunnel project in Oakland, where there was very strong community opposition, the project proponent agreed to mitigate the noise down to background ambient levels. And it says here they used a 35-foot high temporary noise wall, and it says we calculated that the use of the noise wall would reduce the noise level from construction activities to ambient background noise levels at nearby residences. And then the next page is a picture of the temporary sound wall. And so given the very strong community reaction that you saw in those comments, do you think it would be reasonable, rather than the 60 dBA, to to try to mitigate it down to ambient background levels, which I believe were 52.
Objection, relevance. Also, there's lack of foundation. This document is being asked the witness as a reasonable standard, but it doesn't actually provide what the ambient background noise was, where this project was specifically. And it feels like an incomplete hypothetical without that information.
The objection noted with respect to the limited information.
Well,
Mr.
may I say
Vogt, to
something?
the extent you can respond. Now I've lost the question though. Mr. Brodsky, can you
Yeah,
state the
so
question again?
so mitigating down to ambient background levels means that the noise from the project would not be noticeable. Is that correct, Mr. Volk?
I wouldn't say that's accurate. I mean, I think if you're mitigating down to ambient background levels, it would still be intermittently audible because of the time varying nature of noise. On a average hourly basis, if you, like we were talking yesterday about average sound levels, if you're talking about the average ambient level, then you could mitigate down to the average ambient level.
Okay, and if you mitigate it down to the ambient average level, that would be less noticeable than mitigating to 60 on our project. Is that correct?
Well, yeah, well, as we were talking about the monitoring, the level that we measured during monitoring during the fall of 2020 was 52 decibels. So if we, but this is hypothetical. If we mitigated down to 52, yes, it would be less noticeable than 60. However, I just want to note that this document that you're describing, you're talking about mitigating to an ambient level in an urban setting. So I don't know that it's really necessarily comparable. So without knowing the ambient level, it would be difficult to really judge what the effectiveness of the mitigation. But this is a possible mitigation measure outlined in the permit terms for the project. This is one of the mitigation measures we identify as implementing sound barriers where necessary to reduce noise in the excuse me in certain cases where we have sources that need to be mitigated to address noise concerns in the community.
And I do believe those are also in mitigation measure NOI-1 that we will be using sound barriers following the monitoring to determine if we exceed the thresholds.
Okay, well, given all that, then do you think it would be reasonable to do some more work and see if you could develop a plan to mitigate down to background levels for Hood?
Vague and ambiguous, that's reasonable.
Overruled.
It was done on another similar project. Granted, there's differences, but just do some more work and let's find out if we can do it here.
Mr. Brodsky, let's let the witness answer the question.
Thank you.
Please.
Well, I don't really know how to answer that given this situation. I mean, again, you're talking about ambient levels in a city.
Okay.
I think sound barriers would be effective in some situations, and they would, a wall of a sufficient height where you're blocking the line of sight to equipment would provide 5 to 10 decibels of noise reduction to those areas. So I think there's opportunities for where noise barriers could be employed to be acoustically effective.
Okay. All righty, let me just clear this off here. Okay, so next, I hit something by mistake, but that's okay. Okay, so next I'd like to go to AHO 1183 at PDF page 66.
Find something, Mr. Brodsky, let us know.
I'm sorry?
Are you looking for a particular location?
Oh, I was looking at another document. I was waiting for AHO 1183 to come up. I don't see it.
Oh, I'm sorry. I thought
Is
we
it
were
on the
there.
screen?
Is this AHO 1183? I'm asking the team here.
Well, there it is. I'm sorry, I didn't see that. I'd clicked the wrong button.
Oh, okay.
I apologize. Then PDF page 66.
I believe we're there.
Okay, and then lines 25 to 33. It says there a daytime exceedance would occur if on-site equipment or truck noise during daytime hours exceeds the 60 dBA. And then down below line 31, in the event of an exceedance, DWR will contact affected residents to offer short-term or long-term relocation assistance. So as I understand it, that proposed mitigation there is that if it exceeds the standards, you'll ask people if they want to move out of their homes and you'll put them up in a hotel, or is that what that means?
This is a measure which is a resource that is available through the ombudsman to monitor sound levels for people who would like to have it measured continuously during construction. And yes, the part that you're referring to, lines 31 through 33, is a resource that's available, relocation assistance if desired, for those residents that are annoyed by the noise levels occurring. However, I just want to indicate that, as we described on several occasions, the construction would be done during the day, during times when people are generally active during the day, and people are less sensitive to noise in general. But that doesn't account for everyone. So this is to assist residents who would be interested in this type of measure or service.
So
And if I may point out, this is a mitigation measure, NOI-1, so it is part of our mitigation measure monitoring and reporting plan.
Okay, and so this kicks in if you have a situation where it exceeds the 60 dB, it exceeds what you expect and hope it to be, right?
If I may, I believe that this is part of the process that they would be doing with the monitoring and working with the ombudsman to work with the individual residents, commercial businesses, whatever, that want to participate in this part of the mitigation measure.
Right, I understand that it's voluntary, but it occurs, it says, in the event of an exceedance. So that means if the sound level is louder than you expect and hope it to be, that's when you're going to offer them relocation, correct?
That's what it says, yes.
Okay, thank you. So wouldn't it be more reasonable? In other words, if it gets louder than you expect and want it to be, according to your calculations, wouldn't it be more reasonable to fix the problem and put in additional noise shields or stop the equipment or something
Objection.
short of asking people to move?
Calls for speculation.
If
Just
you have a
answered.
professional opinion, Mr. Volk, you can respond.
Well, as outlined in the permit terms and mitigation measure NOI-1, there are a number of options, and this is just one among several. I mean, sound barriers would be appropriate in some cases. Sound insulation may be appropriate in some cases. Sound level monitoring is just another measure that would be available through the ombudsman to interested parties.
Okay, thank you. Okay, now I'd like to turn to another subject. And that's AHO 1183 at PDF page 30. And I've noted your line 26. Okay, and this I think is either for Mr. Murdoch or Ms. Buckholz, but whoever knows. 26 to 27 says at each intake, in-river cofferdams would be constructed with interlocking sheet piles. And so there are a number of different types of piles, right, Ms. Buckholz?
There are, and I would like to have Mr. Murdoch respond on this part of the engineering
Okay,
issues.
fair enough.
Yeah, yes, there are a number of different types of piles.
And interlocking sheet piles is one of those particular types of piles.
Yes.
Okay. And then I'd like to go to PDF next page, page 31 at line 30. And that says that the foundation piers for the intake structures would be installed using drilled piers.
That's correct.
Correct. And so the foundation piers for the intake structure that's being described here, that's in a different location than the sheet pile for the cofferdam, right?
It's in a relatively same location. I know there was some confusion on this yesterday. Would you like me to help explain the location of these
No,
facilities
let me
next to one
rephrase that.
another?
Let me
Yeah.
rephrase that. I shouldn't say that. The foundation piers and the sheet pile are both part of the intake structure, but they're different parts of the intake structure, correct?
Yes, the sheet piles make up the cofferdam that'll be constructed, and the foundation piers are below the intake structure itself to provide foundation support.
Great, I appreciate that answer. Okay, and so Mr. Volk, then, when you analyzed the noise from piles and piers, you assumed that sheet pile would be used for the cofferdam, correct?
I'm sorry, your audio cut out for a second. So can you repeat the question?
I'm sorry. When you analyze the noise, different types of piles and different types of installation procedures produce different amounts of noise, correct?
That's correct, yeah.
Okay.
There are three methods that were analyzed in our noise model. We looked at vibratory and impact driving for the cofferdam, and we looked at vibratory driving for the foundation piers and drilled augering for the installation of the piers. Or rather, I should say the vibratory was done for the starter casings for the drilled piers. So the vibratory driving of the starter casings would be just in order to align the piers appropriately within each of the casings. And that's a vibratory process, not an impact-driven process.
And the vibratory is quieter than the impact, correct?
Yes.
Okay. So if at that, look, the function that those foundation piers serve, which is supporting the intake, if that were changed to a different type of pile, say, for example, a 42-inch impact-driven steel pile, that would require a different noise analysis, wouldn't it?
Well, certainly it would not be the same noise analysis.
Okay. And your analysis did not include an analysis for a 42-inch diameter impact-driven steel pile.
Objection misstates testimony.
I'm asking you, did your noise analysis include the analysis of noise from 42-inch diameter impact-driven steel piles?
No.
Maybe I'll just add the conceptual design that was provided did not use impact-driven piles. They were drilled augered piles.
Right. And Mr. Volk, you used that as the basis for your analysis, correct?
Yes.
Okay. All right, that covers that subject. Thank you. Okay, and then I would like to, we're getting close to being done here. So Miss Buckholz, we talked yesterday about the stakeholder committee, and you said you learned about several problems associated with using barges through the stakeholder committee, correct?
Yes,
And I'll call those things you learned about barges at the stakeholder committee barge problems.
that's true.
And the question is, do you know if DWR was told about the barge problems prior to the stakeholder committee process?
I do not know that.
Thank you. We also talked about yesterday that during the stakeholder process, you considered several benefits that flow from using an eastern route. Is that correct?
That's true.
And I'll call those the eastern route benefits. And the question is, do you know if DWR was told about eastern route benefits before the stakeholder committee process?
There were knowledge of the Eastern Route areas and not identical. We looked at those during water fix as one of the alternatives. Consider it at that time as a proposed project. And then when we went to DCP, we started looking again. One of the things that happened in DCP was to we had to move fix. One was to eliminate, because of the hydraulics, we were able to end up moving the pumping plants from the intakes. We were able to move the pumping, or to move and eliminate the intermediate forebay. And then we looked at putting the Twin Cities Complex tunnel launch shaft first on the west side of I-5. That was considered, but we received many comments from Stone Lakes National Wildlife Refuge. Therefore, we moved it to the eastern side of Interstate 5. Once we moved the Twin Cities tunnel launch shaft to the eastern side of
I'm sorry, Ms. Buckles, this is
before
when,
the
I'm
Delta
sorry, I
Conveyance
lost you.
Plan, this is why we went towards the eastern alignment, was because of the placement of the Twin Cities tunnel launch shaft, not because of previous comments or anything.
What you were just describing, those considerations, I'm not sure I heard you correctly. That occurred when? During the water fix process?
No, that was during the Delta Conveyance Project
Delta
process.
Conveyance process.
And it was concurrent with the stakeholder engagement committee process.
Okay. Concurrent. But what about before the Delta Conveyance project and before the stakeholder process? Do you know if DWR was told about Eastern Route benefits?
Objection asked and answered several times today and yesterday. Also, this Eastern benefits is not a clear definition. I know Mr. Brodsky defined it, but it was just, I'm going to call them Eastern benefits without any detail. And so it's vague and ambiguous.
The objection's noted, but Ms. Buchholz, to the extent you can answer, please do.
The item seems, I apologize, but it doesn't seem, it's more like it sort of related, but apples and oranges. And we did not, DWR did not this, and the development of the Eastern Alignment and Delta Conveyance Plan process planning was done, as I said, for a different reasons.
I'm not asking you about the reason. And I haven't gotten an answer yet. Just before the Delta Conveyance project, before the stakeholder committee, those things that you say you learned at the stakeholder committee
yes,
about Eastern Route benefits.
Yes.
Was DWR told about those before the DCP and before the stakeholder? If you know.
Objections.
Well,
they're not consistent in my mind. In my mind, we made these changes when we proposed initially to look at the Twin Cities launch shaft on the west side of I-5. We heard concerns, Stone Lake were concerned about habitat in that area. We moved it to the east side of I-5 And that's when it made sense to start looking at an eastern alignment.
Well, I just, you're
So
not answering.
we didn't consider previous
I'm not asking
information.
what you considered when you made your decision. I'm not asking if anything was correct or what the import of it is. I'm just asking those things that you discussed at the stakeholder committee as Eastern Route benefits. Do you know if anybody told DWR about those same Eastern Route benefits before the DCP and before the stakeholder committee? And if you don't know, you don't know.
Objection asked and answered. Also, I'm going to object to relevance again as yesterday. What is the probative value of whether or not it was at SEC and someone told them? The testimony has been that these items came out of the SEC and through design in response to community feedback at the SEC. Both can be true.
Thank you, Ms. Morris. And your objections noted. I share I'm also puzzled as to the probative value. However, I'm going to let Mr. Brodsky follow up on this just because I don't think I've heard a clear answer on the question he has stated now, I think 3 times. And I know Ms. Buchholz, to the extent you can answer directly, please do. And if you don't know, then you don't know.
I'm not aware of any communications with DWR associated with at that time, the Eastern alignment for water fix.
Okay, thank you very much. The probative value is, if you would like me to answer that now, or would you not?
I prefer not, because I think I'm allowing you to ask the questions. So
okay, I appreciate that. With that, that concludes my cross-examination.
Thank you, Mr. Brodsky.
Thank you.
I believe, and we're at 9:58, so I'm inclined to move forward. I believe next is Mr. Cho, who we already have up as a panelist, it looks like. With that, Mr. Cho, do you have questions for these witnesses?
I do. Thank you. Again, good morning, Austin Cho on behalf of North Delta Water Agency and Reclamation Districts 999, 2060, and 2068. I do have some questions I believe are largely for Mr. Murdoch, although Ms. Buchholz, there may be some that involve your expertise. So let's just see where this takes us. If we could please pull up Mr. Murdoch's testimony, DWR exhibit number 1. And on page 2, lines 15 through 18. Thank you. Mr. Murdoch, the Stakeholder Engagement Committee was formed in part to identify ways that the project design could minimize adverse construction impacts. Is that correct?
Is there a statement in my testimony that you're reading that from, or are you just asking in general?
It could be in general, but I'm also referring to lines 15 through 18.
Yes, it was.
And Ms. Mullen, if we could please scroll to the bottom of page 16. Starting on page 16 and then going on to page 17, Mr. Murdoch, your testimony states, or rather you refer to properties with water rights within the vicinity of the intakes and other DCP facilities that may be affected by DCP construction. Is that correct?
That's correct.
Did you intend for your testimony regarding the impacts of construction on existing water rights to be a bullet under paragraph 41, which pertains to road conditions?
Yeah, I'm looking at the other pages to see if there's carry on reason. I would, I mean, I did, I mean, this is where it shows up. I would assume that this is also relevant with the intake access haul roads and construction that's required for that and just in the vicinity of the intakes.
Did you only analyze impacts to water rights in the context of potential modifications to roads?
Um, I guess I did not do an analysis of water rights, but I'd ask that maybe Miss Gwen Buchholz could help provide clarity.
We reviewed each of the potential construction sites, determined using the State Water Resource Control Board publicly available database to determine if there were water rights that could be affected either directly on the property that we looked at for construction, or that could be affected on adjacent properties due to the construction on the adjacent properties. So we looked at that for the intakes and all of the construction sites, including road.
If I'm hearing you correctly, Ms. Buchholz, the water rights analysis that was done was not limited to road widening for a combination of construction traffic?
No, it included the road widening, and we did have one road widening that could affect a water right, but we also did it on all of the construction sites.
But based on your understanding of the analysis that was done, Ms. Buchholz, is there a reason in your mind why this would be a bullet point underneath paragraph 41?
Objection, relevance.
Overruled.
I don't know why this was formatted this way.
Thanks. I can move on. Mr. Murdoch, if project construction interferes with the exercise of an existing water right, such as, for example, rendering a diversion pump inoperable, would that be an adverse construction impact as that term is used in your testimony?
Objection, incomplete hypothetical.
I'd like to, or sorry, hearing officer.
Ms. Morris.
Oh, I said incomplete hypothetical. I don't understand what damage to a pump Mr. Cho is talking about. It seems pertinent to be able to answer the question.
Mr. Cho, do you have additional clarification?
It was an example of a potential interference with a water right caused by construction.
All right. Mr. Murdoch, please.
I guess, would you like to clarify the location you're thinking of? I assume it's at one of the intake structures.
Sure, let's go with that. If construction of an intake structure interferes with the exercise of a water right, would you consider that interference an adverse construction impact as you use it in your testimony?
I guess I'd like to have Ms. Gwen Buchholz answer that as related to the adverse impact.
So the conceptual design includes methods so that we would continue to provide for properties that were adjacent to or could be let's use the hypothetical of an intake along the water body that delivered water to an adjacent property, that there would be numerous methods to maintain, and it's in our mitigation measures, to maintain the connectivity of the water body to the property that's using that water right. And so that water would be, there would either be potential for changing some land use boundaries or they would continue to have that water delivered to the adjacent properties.
I
And if
understand.
the property that was the construction, that's a different issue, if that was property that was acquired for construction.
Sure, and I understand and appreciate that. I think it's getting a little bit ahead of what I'm asking here, Ms. Buchholz. And Mr. Murdoch, I'm actually focused on your testimony, since you state in your testimony that the SEC was formed to identify adverse construction impacts. And I'm asking whether this item that you list as a bullet point in your testimony relating to interference with water rights by construction would be considered an adverse construction impact as you use it, Mr. Murdoch.
So the I guess, as I stated in my presentation yesterday, that where water rights are located on the river and that riparian right cannot be maintained, we will be working with the water right user, the water user, to provide land continuity to such that they can still maintain their riparian water right. That's also a permit condition, permit term number 30.
Yeah, I promise you we'll get to all of those. I'm asking sort of at the first part of this analysis, though, before we move on to mitigation and ways that DWR might address these effects of construction. I'm talking about the initial interaction between DCP facility construction and the exercise of water rights that are within the construction footprint. If the construction is interfering with the use of a water right, I'm just asking if that falls within the category of adverse construction impacts that you say the SEC was formed to identify.
Objection asked and answered.
It has not been answered yet.
Let me try to answer this. We recognized during the SEC that at the intakes, there were several water rights at all of the intake sites. We recognized that those could have been an adverse impact if not mitigated. So we did provide, we discussed these issues at the SEC at the intake sites intake sites 2, 3, and 5. Actually, at all 5 intake sites. So we did discuss this at one of the SEC meetings. I don't have the date in front of me right now. And then we talked about how they would be mitigated, how the project description would include best management practices, or how they would approach that so that it would not become an adverse impact. But without those mitigations, they could be an adverse impact.
Thank you. That's helpful. Mr. Murdoch, I believe that you touched on this, but I just want to make sure I have a full picture of how you would define the term. How would you define an adverse construction impact on a water right?
Objection calls for a legal conclusion.
Overruled.
I guess I'd like to state that, water rights are not my expertise. But if a person could not receive their water, to me, that would be an adverse impact.
Thank you. And then, moving on to what you were going towards, you state in your testimony that measures will be implemented to address interference with existing water rights. Is that correct?
Can you show me where it says that in my testimony?
Sure. Starting on the very bottom of page 16, line 23.
Oh, yes.
And then if we can move a little bit further down on to page 17. And this refers to the provision of land-based continuity that you mentioned earlier, Mr. Murdoch.
Mm-hmm.
And it also states that DWR will modify conveyance facilities to maintain water right deliveries in the manner used prior to DCP construction. Is that correct?
That's correct. That's what it says.
And you cite a few exhibits here for the statement that DWR will modify conveyance facilities. Ms. Mullen, do you mind pulling up exhibit AHO 1101?
Uh, did you mean DWR 1101? You referenced the site, and this is not a site in Mr. Murdoch's
sorry.
testimony.
Yes, I'm sorry. I meant DWR 1101. And if we could go to page 8 at proposed permit term 30. And this is the permit term you referenced in your testimony. Is that correct, Mr. Murdoch?
Yes, it is.
And this proposed term states that if DCP facility construction will interfere with continued use of a remaining parcel's riparian rights, measures will be implemented by DWR. Is that correct?
That is correct.
Is it also DWR's intent that if DCP facility construction interferes with the continued use of an appropriative water right, that measures will likewise be implemented by DWR to mitigate such interference?
Calls for a legal
Objection.
conclusion.
Overruled. To the extent you can answer, Mr. Brown, please do.
Yeah, I guess my familiarity with water rights and appropriative rights, I'd like to ask Ms. Gwen Buchholz to help with that question.
We have mitigation measures in both the chapter 13 of the EIR for agricultural. No, it's not 13. It's the agricultural chapter, and also the public utilities chapter, that whether it's an appropriative water right or riparian water right, that there will be methods to maintain and the continuity of those continued use of those water rights on adjacent properties.
Does permit term 30
and water supplies too.
But does permit term 30 apply to appropriative rights or only riparian rights?
It references the riparian. I don't know the way it's written, if there was a need to add the specifics of appropriative, but the EIR, it's included in there.
Ms. Buchholz, do you know that whether a construction impact on the ability to exercise an appropriative water right would also be a construction impact in the same manner that interference with a riparian right would be?
Calls for speculation, hypothetical.
Also, it might help if there's a specific question about at a construction site. I think the question is vague and ambiguous as to the location of where the appropriative right would be exercised and what the interference with the water right would be.
Mr. Cho, I would like to follow this line of questioning, but let's try, maybe you can break down your question or be more specific.
Sure. I'm happy to refer back to Mr. Murdoch's definition of what an adverse construction impact on a water right generally would be, which was the inability to get the water that a water right holder is entitled to. Is that a accurate enough summary of what you responded, Mr. Murdoch?
Yes, and I would like to clarify that I am not a legal expert related to water rights, so I would not rely on my definition.
That's perfectly fine. I'm merely exploring just the scope of your testimony, Mr. Murdoch, and what you provided here. So, Mr. Murdoch, do you draw a distinction? I know that you are not an expert on water rights specifically, but you understand that there are riparian water rights and there are appropriative water rights under California law. Is that correct?
objection calls for a legal conclusion.
Based on your knowledge, Mr. Murdoch, you can answer.
I am vaguely aware of those type of water rights. Again, I am not a water rights legal expert.
So within your knowledge of this proposed permit term that you cited in your testimony, are you aware of any reason why riparian rights would be identified but not appropriative rights?
Same objection.
Noted.
I am not aware.
And Ms. Bugles, are you aware of why only riparian rights are mentioned here?
Hearing Officer Kinsey, since this is a permit term that DWR proposed, I understand it's cited here. If I could offer an explanation, the intent is to, if the construction at the intakes or Twin Cities complex or Lower Robert Islands interfered with the riparian parcel, meaning it cut it off because it is no longer contiguous with the riparian, with the source of water, that we would look for land-based continuity so that we did not sever a riparian water right and its use. These witnesses are here to talk about construction. If Mr. Cho is asking if the construction of the two BCP intakes, Twin Cities complex, or Lower Roberts specifically interfered with an appropriative right, it would be a different story. If he wants to talk to us about a permit condition, we're more than happy to continue settlement discussions to address this issue. But this line of questioning without specific instances of what that harm would be seems inappropriate. And quite frankly, we're willing to work with him if he has a specific scenario.
So Ms. Morris, now I'm more confused about this term. So let's talk about this term, and this is not on your time, Mr. Pause. I'm taking the time. So your reference, what you described, I think, was a severance. Did you mean like a legal severance in the terms of an exercise of eminent domain or a change in the parcel that would sever the parcel from the Sacramento River or another, whatever the waterway to which the parcel is riparian? Is that what you were describing, Ms. Morris?
That is what the land-based continuity portion of this permit condition provides for. If a parcel, for example, has continuity along the front and the intakes were to take the whole parcel or purchase the whole parcel in the front, it would require the back parcel to be separated so that the landowner may choose to continue to use that land. In that instance, we to that back parcel. I also want to specifically say that, the second part of this permit term, the sentence says that we will modify conveyance facilities to maintain water rights deliveries, which is not limited to riparian rights.
So this permit term does not address the situation where construction activities may interfere with the exercise of a riparian right, absent a severance of the parcel from, in a legal manner, because of conveyance. It does not address
That's not correct.
that.
No,
Okay.
it does address that. And it addresses two. Am I breaking up or can you hear me okay?
There are occasions when you cut in and out, but right now I think you're fine.
The first sentence is dealing with riparian rights and land-based continuity. The second sentence, as it relates to construction sites that are listed in the permit term, are talking about interference with water rights that do not require a land continuity connection. So the way you described it was not how the intent of the way it was written.
So the title land-based continuity of this permit term is under-inclusive. because it addresses other things.
Correct.
Okay.
Hearing Officer Kinsey, this is OSHA Meserve. May I speak?
Please, yes, Ms. Meserve.
I have an objection to this entire colloquy between Ms. Morris and you regarding the meaning of DWR's permit term 30. It is my understanding that DWR has not put forth a water rights witness in order to testify on the issue of water rights. And I don't think that their attorney should be able to offer testimony into the record when DWR has failed to put forth that witness. Thank you.
Thank you, Ms. Meserve. And this, just to be clear, this exchange back and forth, it's non-evidentiary, right? It's not testimony. It's a discussion of the language.
Not testimony beforehand. Station started.
Ms. Kinsey,
Yes.
Ms. Kinsey, this is Kelly Tabor on behalf of Sacramento County et al. And I would like to second Ms. Meserve's objection and move to strike all of Ms. Morris's testimony regarding the permit term. Ms. Morris has not been sworn as a witness, and she's testifying as to the intent and meaning of these permit terms.
Noted. Thank you, Ms. Tabor. And again, it is non-evidentiary, and I'm noting that for the record. We'll go to Ms. Desjardins, and I see you, Ms. Morris, as well. Ms. Desjardins.
Thank you. I would like to also affirm the request by Ms. Tabor and the concerns expressed by OSHA Meserve. My own concern is that Ms. Morris testified that the scope of the panel was simply on construction, but it's also on the design of the intakes. There's technical memos about the intakes. They're very large. They can interfere with water rights. So I do object to Ms. Morris testifying incorrectly about the scope of the witness's testimony. Thank you.
Thank you, Ms. Desjardins. Ms. Morris.
Thank you. I'm not intending to testify in any way. However, as part of the hearing notice, it was suggested that DWR submit permit terms. These permit terms go beyond witnesses' expertise, and I was trying to provide clarity about the permit term and the intent that DWR intended, which is not evidence, but it is an offer to work with Mr. Cho to clarify because of the confusion that I see that is occurring.
Thank you, Ms. Morris. I appreciate that. And I think now I've interrupted us enough. It is back to you, Mr. Cho.
Thank you. I will just for the record also join in the objections that Ms. Meserve and Ms. Tabor lodged and join in that motion to strike for Ms. Tabor, since I believe Ms. Morris just undermined the point about not testifying when she's clearly trying to offer clarification and interpretation of this exhibit, which was provided in the testimony of a DWR witness. But I can move on.
Thank you. Please do.
Thank you. So, Mr. Murdoch, were you involved in the drafting of this permit term at all?
No, I was not.
So in your testimony, in which you state that DWR will modify conveyance facilities and provide land-based continuity, that those statements, are you relying on this exhibit?
I was made aware of this permit term. So when you asked earlier, was I involved in drafting of the term? No, I was not.
But you are essentially taking what this permit term states, and that is the entire basis of your testimony. On that
Objection misstates testimony and the witness's written citation.
Try the question again, Mr. Cho.
Is your testimony, Mr. Murdoch, that DWR will provide land-based continuity between the water source and water rights holders of land, or I'm sorry, and water rights holders' land, and modify conveyance facilities to maintain water rights deliveries in the manner used prior to DCP construction based on anything other than this permit term 30 as it's written?
Um, I I believe that I guess I'd like to look at one of the other exhibits, which would be the EPR narrative report. I would need to go back and look at that document and see if that was mentioned in there as well, and I relied on that.
Okay. I don't think we need to open that document just yet. We may if we get to it. Let's stay focused on this permit term for now. How do you understand the term land-based continuity? What does that mean to you?
It means that the land for which the water will be used needs to be in continuity with the river.
And this permit term also states that DWR will modify conveyance facilities. What do you mean when you use the term conveyance facilities there?
It will modify either existing facilities that are used to convey water from the river to the land. So as we proceed with the design phase, we will modify those facilities if needed to provide that conveyance of water to the land.
So I want to try to understand the nature and the scope of this commitment as provided in your testimony. Let's maybe take for example, if I'm a farmer in the North Delta and I own and operate an irrigation canal, and the DCP construction activities render that canal inoperable, will DWR modify the canal to make it fully operable, no matter what the cost?
Objection, incomplete hypothetical, assumes facts not in evidence, vague and ambiguous as to inoperable.
Noted, but overruled.
You understand the question, Mr. Murdoch?
I do, but I would like to understand specifics. I guess what you asked had a lot of I couldn't connect exactly what you were describing about.
Well, can you picture an irrigation canal?
Mm-hmm.
And
yes, I can.
Are there aspects of facility construction, let's take one of the intakes, that could potentially interfere with the use of an irrigation canal?
I guess I would need to look at the intakes and the location of the existing canals. Maybe Miss Gwen Buchholz has better understanding of the facilities that are out there. Gwen, would you like to help?
Yes, we recognize that there's both irrigation and drainage facilities on the near and on within and near the intake sites. And that's one of the reasons that DWR issued mitigation measure AG-3. And there's a bullet point in AG-3 that talks specifically about relocating and or replacing wells, pipelines, also, and drainage systems and other items I remember in AG-3. And that would include those types of things if they were adversely affected through construction or of the project.
Thank you, Ms. Buchholz. So to your understanding, this commitment to modify conveyance facilities includes potentially replacing conveyance facilities at a different location?
The words in HE-3, we could bring that up if I knew the exhibit number, would be specifically to relocate and or replace wells, pipelines, power lines, drainage ditches, and other infrastructure needed to support ongoing agricultural uses.
I don't know if we need to open that mitigation measure at this point, because I'm trying to understand the basis for Mr. Murdoch's testimony, which does not refer to that mitigation measure. I'm trying to understand what this commitment actually entails. Are you saying that the mitigation measure that you referenced is basically constitutes this commitment to modify conveyance facilities?
It is part of the overall project description for DCP, yes.
Okay, so going back to my hypothetical regarding a North Delta farmer who operates an irrigation canal that is rendered inoperable by the construction of the project because whether there's a physical obstruction or other reasons that are within the umbrella of construction impacts, would DWR take those mitigation actions, be it modification of facilities or replacement potentially, regardless of the cost of doing so?
That's what's addressed in this mitigation measure.
Thank you. Going back to you, Mr. Murdoch, I believe you stated already that you do not have any expertise in water rights. So is it safe to assume then that you are not responsible for identifying the water rights and diversions that would be adversely affected by construction of the DCP?
In the role that I serve, I would usually rely on others to identify those water rights and locations. So I would not be identifying them.
Who did you rely on?
I relied on Miss Gwen Buchholz to help with the preparation of my testimony.
So Ms. Buchholz, were you responsible for identifying those water rights and diversions that would be adversely affected by DCP construction?
Yes, we specifically talked about them in the engineering project report, and we used the public or the available database from the State Water Resources Control Board to identify the water rights that were either within the construction parcel or on adjacent parcels.
Ms. Buchholz, did you or anyone else affiliated with DWR conduct a search for existing water rights beyond that vicinity of that immediate vicinity of the construction footprint?
If it would depend on how we saw the water right on the database and the adjacent, we pulled up the water right permits if they were available to see how that would happen. We had several cases in which there was a use of ditches, roadside ditches, drainage ditches, whatever, that we actually used to convey water rights in an appropriative manner. And we tried to follow that as far as we could with the publicly available data. As we go further into design, we'll be needing to obtain more additional information on this aspect of the project.
Did you or your staff conduct any field observations?
We've conducted field observations to the extent that we had access from publicly available roads.
Ms. Mullen, I sent a document to the AHO email address. Are you able to pull that up?
And Mr. Cho, would now be how much longer do you think you have? Let me ask it that way.
I have maybe 20 more minutes, or no, probably 15 minutes.
I think it would be a good time for a break. We've been going for a little while, so let's go ahead and take a 10-minute break. We'll come back at 10:46. Thank you. Right, it is 10:46. I will look to our court reporter. Are you ready for us to go back on the record?
Yes, ma'am.
Thank you. And with that, I will turn things, well, let me make sure that I have Ms. Carroll or Ms. Morris. Are you in the room as well?
Yes, thank you.
Yes.
Thank you. And with that, I will turn things back over to you, Mr. Cho. And you are on mute.
Sorry about that. Ms. Mullen, were you able to find the document that I was referring to?
We have it, is my understanding. I think we'll have it up shortly. There we go.
Perfect. And this document is a DCA technical memorandum entitled Existing Surface Water Diversions - Intakes Final Draft. Do you recognize this document, Mr. Murdoch?
Yes, I do.
Did you rely on this document in preparing your testimony?
Yes, I did.
I don't believe this was identified in it's not a DWR exhibit. And I don't believe that it was identified when Ms. Carroll went through the documents that were used to prepare your testimony. Would you like to make an amendment?
Yes, in my response, this document supported the engineering project reports, which are exhibits 00018 and 00019.
Ms. Mullen, do you mind opening exhibit DWR 18 really quickly? You could scroll to page 8. And I see that on this page, there is a list of attachments, including attached technical memoranda. Is that what you see there?
Yes.
And the third bullet of attachment A looks to be the document that I brought up. Is that accurate?
That is correct.
I looked through the entirety of DWR 18, and I don't believe that attachment A is part of this exhibit. Am I mistaken?
It is not. So I guess if you'd like to clarify my answer, since I started working on the project, all of these attachments that are included with the EPR has been part of the documents that I have been involved in reading and acquainting myself with the project.
But as it stands right now, this specific attachment is not part of DWR's case in chief that was submitted to the AHO.
Yes, that is correct.
There a reason why it's not part of the case in chief?
I do not have a reason.
Okay, well, since it's going to be the subject of some of my questions, maybe if we can just identify this as NDWA-3 for the time being.
For the record, you're not talking about the document that's up on the screen, which
No, I'm
is
sorry, I'm talking about the
DWR 008.
existing surface water diversions technical memorandum. There we go. So Mr. Murdoch, you just to clarify, you did rely on this document in preparing your testimony?
I relied on the EPR narrative and not specifically this document.
But you just stated that this document is part of the EPR narrative. Did you not?
Yeah,
Objection misstates testimony.
Overruled, Mr. Murdoch, if you can just clarify. please.
I guess I'm having confusion as to what the information that's been submitted as exhibits versus the information that helps describe the concept design as it was prepared.
Well, I'm talking about the scope of your testimony and what you are able to speak to today in response to my questions. There's a difference between whether this is a document that you relied on for the purposes of your testimony or if it's not. So I'm just trying to clarify.
Yeah. So since it was not included as one of my exhibits and is not cited in my testimony, I would say that it is not.
Go ahead.
Well, I was going to say, I had Miss Gwen Buchholz help me with the preparation of that. I was wondering if she could provide any clarity.
It's not only, it was considered as, when we talked about it as Mr. Murdoch prepared his testimony, it also was provided in consideration to several of the EIR environmental resource teams, and it's part of the overall engineering project report. So the information in the narrative does refer, I do believe that CE narrative would have referred to this intake TM, but I don't have that narrative up in front of me right now.
So Ms. Buchholz, would you say that you did rely on this document in your support of Mr. Murdoch and his preparation of his testimony?
Yes, I would.
And do you know why this was not submitted as part of DWR's case in chief?
When Mr. Murdoch and I worked together for his testimony, we did not refer back to this specific page. And I don't have a memory right now of how we made that decision.
Is there any other document that was submitted as part of DWR's case in chief that identifies the water rights and the names of the water right holders who DWR believes would be affected by DCP construction?
Again, as Mr. Murdoch said, when we refer to the narrative as using it every day, we basically are referring to a lot of those times to the narrative and the entirety of the EPR, which includes the technical memoranda.
I understand that, but it is true that the entirety of the EPR is not submitted in this hearing, correct?
I would agree with that statement.
And so do you, to your knowledge, Ms. Buchholz, know why this particular attachment of the EPR was not submitted with DWR's case in chief?
As I said, we did not list it when Mr. Murdoch and I worked together on his testimony, because we were considering this part of the narrative as the overall EPR when we used the narrative in that process.
So circling back to my other question, is there a document submitted as part of DWR's case in chief that identifies the water rights and the names of the water right holders who DWR believes would be affected by DCP construction?
I don't believe that is in the DWR exhibits.
We could please go to page 2 of this document. And there's a table here titled Table 2-1, Intake 2 Affected Surface Water Diversions. And maybe this question is for Ms. Buchholz, since you have more familiarity with this document. Is it accurate that this table refers only to Intake 2 in the title?
You are correct. The title is mislabeled. It is also intakes 3 and 5.
Thank you for that clarification. And you stated that you're generally familiar with this table. Is that correct?
Yes,
Did you prepare this table?
I had I had a staff member prepare it with me. Yes,
And who was that staff member?
as you would note, Michael Randall, but I directed his work.
Thank you. And from this table, I see there are a total of 11 water rights listed, 6 of which are marked as permanently impacted, 5 of which are marked as temporarily impacted. Is that correct?
That is correct.
Is this an exhaustive list of the water rights that are potentially affected by DCP construction facilities?
This list was developed from the State Water Resource Control Board database. And then we also received information during the preparation of the water fix EIR and engineering reports that included the 2 line items that are says not in the State Water, the SWRCB database. We continue to include those because we had no, and we had information that was submitted as comments during WaterFix. We did not have any information if they're truly in the database or not, but we included them for our to be aware there's a potential disturbance to those 2 intakes, to those 2 water rights.
So have there been changes to this list since WaterFix, or I guess strike that, please. Have there been changes to this list for purposes of the DCP compared to what was developed for WaterFix?
I do not remember whether that was the case. I know that we re-looked at this database. We didn't just use the table from WaterFix.
Does this list of water rights include any water rights that could be affected by construction of other DCP facilities, namely Twin Cities and Lower Roberts Island sites?
This does not.
Did DWR analyze whether there are other water rights that would be affected in relation to those other sites?
We looked, as I said before, at all construction sites to determine from the public database whether or not the properties, either the property that would be under construction or the adjacent properties, would have any water rights from the publicly available database.
So would it be correct to infer from the omission of any references to water rights in the vicinity of the Twin Cities and Lower Roberts Island sites that DWR determined there are no water rights that would be affected by those construction at those 2 sites?
Objection, misstates testimony.
Overruled.
This technical memoranda was specifically developed only for the intakes.
Was there a technical memorandum developed for the other sites?
There was not.
Do you know why?
The reason that we did the intake was because it became important for us to look at the potential layouts of constructed facilities to determine how to minimize any adverse effects to those water right diversions, the existing water right diversions. We did not see any need to change facility layouts at either Twin Cities or Lower Roberts Island for the water rights on those properties.
In table 2-1, there's a column with the header impacted. It's 3rd from the left. Do you see that?
Mm-hmm.
And if we look at the legend or the notes below, there are letter indicators for temporary and permanent. And those letters are assigned to each of the identified water rights in the table. Is that correct?
That's correct.
What does permanently impacted mean in this context?
If you can scroll down the page, please. We have temporary constructed there. We can continue. I believe we referenced what permanent would be on the following page. Could you scroll down? Hoping. Nope, we did not. Okay, so let's go back to the temporary. So as you can see, that the definition of temporary in the first sentence of the second paragraph under the table, that we could provide water to all or portion of the service area, and there would have to be some modifications, potentially changing of pipelines or maybe moving to the diversion the ditches used to carry that water. That was considered a temporary. A permanent was basically if the intake itself, and this was prepared several years ago, the permanent we assigned in this table was primarily if the intake was located on top of the existing water diversion.
Is there a difference between the use of the word impacted here and the adverse construction impacts as used in Mr. Murdoch's testimony?
This would be, I don't know exactly how to answer that question. This was specifically associated with how we impacted these intakes as the way I described it.
Right, and correct me if I'm misstating, but I believe you just said that you considered a permanent impact was one in which the proposed intake structure would be on top of an existing point of diversion.
Right. And subsequent to this technical memoranda, we have been discussing, although not developed yet, this will be part of design phase. Is there a way to continue to provide water supply from those intakes in a different manner? We do not have those answers yet, but that's one of the ideas to be considered during the design phase. So this is a worst case situation.
But that's not reflected in any proposed term.
No, we don't have that information at this 30, where if they were slightly offset, we could, two things in term 30. One is if we just had to connect the land connection for a riparian right would be one. If there was a way to reconvey the water from the intake area and put it and convey it into the existing agricultural water supply delivery, that was one of the things we'd like to look at during the design phase.
Is there a timeline associated with that plan to look into those other options?
We do not have a timeline at this point. It's right now between now and when construction would be started.
So potentially this could occur after this current proceeding for DWR's petition for change concludes?
It could be, or it could be also considered as part of a change in term 30.
It sounds
it's actually
like
part of, it could also be considered part of the second sentence in term 32, because that's a relocation type question.
right, but as you just stated, DWR has not actually done any analysis on the logistics of doing that, correct?
We have not done engineering analysis.
Is it safe to say that the word interference and the term impact as used in this table and the description that follows are not synonymous?
Can you please, Ms. Mullins, scroll up to the top of the table so I can make sure I'm in the right part there? Looking for the word interference.
Interference is as used in Mr. Murdoch's testimony.
Oh, okay. Could you please repeat the question?
Sure. I am inferring, and please correct me if I'm wrong, that interference, as used in Mr. Murdoch's testimony, is potentially broader than the type of impact that is being discussed in this memorandum.
I don't infer that same conclusion.
So are you stating that when Mr. Murdoch refers to construction of the DCP intakes interfering with existing water rights, that he is only referring to either temporary or permanent impacts as described in this document?
As the basis of construction, yes.
And so the only instance where there is a permanent impact to a water right is when the proposed intake facility is on top of an existing diversion.
Section misstates testimony.
Did I misstate that, Ms. Buchholz?
We looked at the permanent would be that construction of the intake would be at this in the same locations as the current existing diversion. And we'd need to look to see if there was a way to, or the intake or the cofferdam or the training wall or the road extension around the intake. All of those. And that's why there's potential changes that we could put in to make, we think now that we could potentially come up with ways to convey that water around the constructed facilities to continue the use of the water rights to adjacent properties. May I make a point, please, that some of the water rights, and I would have to look at each one, but some of them were wholly to be used within the constructed parcels, the parcels to be acquired for construction. So it really varies each parcel by parcel and each water right by water right, which could have several parcels.
Has DWR already acquired any of the parcels that were identified for acquisition in this table?
No. Or at least not that I'm aware of, but acquisition has not been underway at this time.
And are these listed rights exclusively riparian rights?
Without looking, I couldn't say absolutely, but if my memory is correct, I believe all of the intakes were riparian rights.
Maybe if we could just scroll down further in this document to the first, I believe it's an attachment. Would be maybe the second attachment then. I can find the page for you. Starting on page 9. Do you recognize what this attachment is, Ms. Buchholz?
I do.
This is an initial statement of water diversion and use. And there are a number of statements that follow this, and these are all in relation to the water rights identified in Table 2-1. Is that correct?
That's correct.
Do you see that under item B, directly below the claimant agent information table?
Yes.
A line there that says water is diverted and used under the claim of, and there are a few options there. Do you see what are checked off for this particular statement? You see that a riparian claim is there, as well as a pre-1914 claim?
Right, I see that. So it would also have an appropriative side.
Correct. And I
That's what I
don't,
could not remember without looking at these pages. I apologize.
fair enough. Would it be helpful for you if we went through each of the, I believe, 9 statements of diversion of water use that are contained as attachments here and confirm that every single one also includes a pre-1914 appropriative claim?
We can look through that, and if that's the case and that area is checked, you're right, it is both riparian and appropriative.
Ms. Kenzie, for the purposes of the record or anything else, would it help you? Or maybe I'll ask Ms. Morris, do we need to go through that exercise? Or can I just represent that each of the 9 statements of diversion and use mark a pre-1914 claim in addition to riparian claim?
I think the witness can answer on that assumption for this question only, but if the documents say something else, then the record would reflect that it's your representation.
Let's go with that, if you will, Mr. Cho, and let's go ahead and ask your question and see if we need to go through all these.
Sure. Can we jump back to DWR Exhibit 1101? So, Ms. Buchholz, to your understanding, does permit term 30 address a pre-1914 appropriative claim?
I would look at the second sentence, the part that says, hang on, let me read it for 1 second. It's the second sentence. I was counting periods here. Second sentence. DWR will also modify conveyance facilities to maintain water rights deliveries for the manner used prior to the DCP construction. That would affect both, in my opinion, both riparian and appropriative water rights, including pre-1914s. And that is the way we looked at this at different properties too.
So it is your opinion that that second sentence of permit term 30 is independent of the riparian qualification of the preceding sentence?
That's the way I read it, and it's also, as I said before, consistent with mitigation measure AG-3.
Thanks, Ms. Mullen. Would you mind jumping back to the memorandum regarding water rights? And turn to page 3, please. And I'm almost done. I've got 2 minutes.
For the record, you're talking about PDF page 3 to the extent it's different than the actual page numbers.
Correct. I'm referring to the page that Ms. Mullen is on. Let's see. On this page, let me just double check that I have the right. You see in the top paragraph of the page, the last sentence, it states it would be more useful to, it would be useful to more definitively define the modifications required early in the design development process. You see that sentence?
Yes.
Have modifications been further defined since this 2021 document, Ms. Buchholz?
No, they have not. We don't have access to the properties, and that would have to, we hope during, as we said in other places in the engineering documents, to the process proceeds through design to meet with the landowners and further define that. But we have not started that portion of design development, or started the design development process in this case.
And similar to your other response about forthcoming analysis, is this a process that could conceivably occur after the conclusion of this change petition proceeding?
It wouldn't, in general, it would not occur until we have authority to access the properties and discuss the project with the property owners or the water rights holders.
So is that a yes?
Yes,
Thank you.
depending on how long this process goes.
Of course. And on that point that you mentioned about DWR having some work to analyze impacted water rights, if we could drill down on that briefly. Has DWR analyzed the specific diversion needs of any of the water users that are identified in this document in terms of rates and quantities of water?
No, as I said, we relied totally upon information provided from the publicly available database from State Water Resource Control Board.
And is it your contention that the table is current and complete as far as the State Water Board's EREMS database is concerned?
Based upon
Objection vague as to time.
Time with reference to reviewing the database? Is that what you mean, Ms. Morris?
The question was complete, and it's vague as to time, as he's referring when the completeness.
Right.
Understood. Mr. Cho, if you can rephrase the question.
If we could scroll up a page, Ms. Mullen. You stated previously, Ms. Buchholz, that this list of affected water rights is the extent of the information that DWR has been able to obtain by accessing the State Water Board's publicly available information, correct?
When we prepared this memo, which was actually, so the preparation of this memo was done prior to the draft EIR, which was published in 2022.
And so it's your contention that there are two water rights identified here that are not in the State Water Board database. Is that, do you have any additional information you can provide in there? Has there been any analysis?
We have not completed any analysis. As I said, information had been provided in comments during the water fix EIR, draft EIR review, public review, and we felt that was important to include in this table, though they were not included in the EREMS publicly available database.
Given the lack of analysis of the specific diversion structures, the rates and quantities of water involved in these water rights, how is DWR able to know that the contemplated modifications will be sufficient to avoid the adverse construction impacts that are identified in Mr. Murdoch's testimony?
Well, we look at this, that we have made the commitment, DWR has made the commitment in mitigation measure AG-3 that we will, in the words will, provide mitigation to continue to provide water to the areas that are not within the construction zone. If the water right only provided water to the construction site and did not involve other places, it was assumed and specifically if it was only used on that water right, whether it's riparian or appropriative, then that would not have been included in mitigation measure AG-3. However, if it does affect other properties that were not being constructed on, then mitigation measure AG-3 does require DWR to mitigate this.
Has anybody at DWR or affiliated with DWR spoken with any of the water right holders identified in this list, to your knowledge?
witness to answer, but I will just remind the witnesses that some conversations were confidential settlement discussions.
Noted.
Was that a yes?
I'm with respect to, I was with respect out, except for the settlement conversations, I am not aware of any other discussions.
I know I've been focusing on you, Ms. Buchholz, but this question is for you and Mr. Murdoch. Is the testimony that was offered that we're discussing today relating to adverse impacts on water rights limited to just the construction of the proposed DCP facilities?
That is all we analyzed, yes.
So, and Mr. Murdoch, is that the case for you as well?
Yes, I would agree with that.
So neither of you, as you sit here today, are speaking to whether the operation of the DCP will cause adverse effects to water users within the North Delta. Is that correct?
That is correct. We were not involved in any of that, and I believe that's the team on panel 2 that was analyzing that. But we were not involved at all.
That's all for my questions. Thank you both for your time.
Thank you, Mr. Cho. Ms. Morris.
Yes, I just wanted to say DWR is open and willing to receiving additional information. We are always looking for a more thorough understanding of where water rights are located if they are not publicly available.
Objection.
Just want
Morris,
to make that offer that if anyone has information about those locations that they want to, we would be happy to receive that information.
Thank you, Ms. Morris. And Ms. Meserve?
I was simply objecting because Ms. Morris appears to be testifying again, and I don't think it's appropriate since there's not a witness providing the information.
And Ms. Morris, I did not understand this to be testimony. It's not of an evidentiary nature and it won't be considered that way. On the other hand, I certainly do want to support what I would characterize as settlement negotiations outside of this, related to, but outside of this process. So I think offers to discuss outside of the hearing process are appropriate, although once again, noting that these are non-evidentiary statements.
And Ms. Kenzie, if I could just also join Ms. Meserve's objection there. I think the issue here is that DWR has provided and submitted a list of proposed terms. That list of proposed terms does not include the qualification that Ms. Morris just provided. And so if she's trying to put evidence into the record regarding the what is being stated in those terms, that's just not appropriate at this time.
Understood. It's not evidence. Ms. Carroll.
Yes, I think we would cite to your hearing notices where you encourage the parties to continue discussions, and that is what we're basing our statements off of, is we are open to continuing discussions as you have directed.
Thank you, Ms. Carroll. Ms. Desjardins.
Yeah, I would like to join in the objections. My understanding is that this is appropriate for the protest resolution phase, and we've progressed from the protest resolution phase to the hearing phase, and having attorney interrupt, or at the end of testimony say, oh, we're in discussions, it really confuses the phases of the hearing. Thank you.
Thank you, Ms. Desjardins. I do want to clarify that settlement is appropriate throughout this proceeding and that those discussions are appropriate throughout these proceedings. And I realize that some elements of dispute in this proceeding may be irreconcilable, but to the extent that there may be certain issues that can be resolved, it's my intent to support those conversations while efficiently moving forward with this hearing. I see another hand. Mr. Moore. Oh, the hand went down. Mr. Moore, if we can please bring Mr. Moore up or grant him privileges. There you go. You can unmute yourself, please.
Can you hear me okay?
Yes, I can.
Okay, I didn't know if it got turned on or not. I just want to strongly support the position of the other protestants objecting to this attempt to interject things into the water rights discussion here under the ruse of an invitation to settlement. Settlement discussions, while they may proceed, do not have to be interspersed the way that is being attempted here. That even though you've correctly recognized it is not evidence, it's clearly being interjected here as an attempt to place a gloss on the evidence and testimony that we're being considered. Let's be real here. This is not being raised today by Ms. Morris because she really thinks that we are going to get a settlement out of the discussion today. It's because she wants to characterize the evidence in a certain way. We should focus on that.
Thank you, Mr. Moore. Ms. Meserve, I'll allow it, but I'm getting to the end. I've taken the point. Do you have something to add?
I was just going to acknowledge that I'm quite aware that there's been an offer for further settlement negotiations, and I do work with many of the intakes owners have submitted protests specifically. So I'm aware of that, and so it's really not necessary to bring it up here anymore. Thanks.
Understood. Thank you. Mr. Moore, is that a residual hand?
It's a residual hand. My apologies. I got it to work now.
Thank you. We're all getting used to it's some elements of Zoom. With that, where are we? It is 11:28, so I think I'd like to continue with some cross-examination. According to my list, Ms. Tabor, I believe you are next on the list, and we can bring Ms. Tabor up to panelist, please. Welcome, Ms. Tabor.
Good morning.
Good morning, and you're welcome to proceed with your questions when you're ready.
Thank you. Good morning, panelists. My name is Kelly Tabor. I represent the County of Sacramento, Sacramento County Water Agency, Sacramento Area Sewer District, the City of Stockton, and Byron Bethany Irrigation District in this proceeding. And this morning, I'll be starting with cross-examination on behalf of those parties, and my questions will primarily be directed at Mr. Murdoch, perhaps also Ms. Buchholz. And when I'm done, my colleague Casey Shorrock will be asking questions primarily to Mr. Volk. So if we could promote Ms. Shorrock as a panelist. I don't know if you want to do that now or when I'm finished, but I just want to let you know that she'll be prepared to jump in. I don't think that we will get to her before the lunch break, though.
Okay, well, maybe we will leave Ms. Shorrock if you're willing. Where she is, we'll bring her in. Unless you think, is there any reason she would need to interject?
No.
Okay, then we will leave her, and she has a control of her microphone now, so we have at least that. Please go ahead, Ms. Tabor.
Okay, great. Thank you, Mr. Murdoch and Ms. Buchholz, for being here to answer my questions. Ms. Mullen, could we start with you please pulling up Mr. Murdoch's testimony, Exhibit DWR1? And if it's okay, I'll omit using all the zeros that are in front of each exhibit for DWR1. I mentioned those. And if you could thank you. Scroll to the bottom of page 4, around line 19. Okay, great. Thank you. So, Mr. Murdoch, directing your attention to your testimony starting on line 19 that the SEC members included Sacramento, Yolo, San Joaquin, and Contra Costa counties. What is the basis for that statement?
The basis was to indicate who some of the participants were in the stakeholder engagement committee meeting.
Okay. Are you, do you have any personal knowledge whether any of the those counties are members of the SEC?
The stakeholder engagement committee was before my time, so I don't have any personal knowledge.
Ms. Buchholz, are you, do you have any personal knowledge regarding the membership of the counties in the SEC?
The in our community effects technical memoranda, which you like to get the exhibit number. It's exhibit DWR. Isn't it exhibit? Exhibit. I can't find the exhibit, but in there we have on the first on the PowerPoint slide of the first meeting, we listed the people who had agreed at that time to be on the stakeholders engagement committee. When we talk about this bullet point on Sacramento, Yolo, San Joaquin, and Contra Costa counties, those were not necessarily members of county staff, but people who lived in those counties.
Okay, so in light of that, Ms. Buchholz statements, and Mr. Murdoch, would you choose to clarify your testimony that the statement that the SEC members included the counties meant that the members included residents of those counties and not the governmental entities or staff from the governmental entities of those counties?
I would defer to Miss Gwen Buchholz as she was involved in the SEC meetings.
The bullet is the bullet is the residents of those counties.
Okay, in light of this, since this is your testimony, Mr. Murdoch, in light of Ms. Buchholz's statement, would you agree that your testimony that should be clarified to reflect that the members included residents of those counties?
Yes, I would agree.
Okay, thank you. Ms. Mullen, if you could please scroll now to the top of PDF page 8 of Mr. Murdoch's testimony. I'm just going to state right here that to save some time, I'm going to make a few statements regarding things that have been covered extensively in the prior testimony, and I'm hoping we don't have to pull up separate documents in order to agree to discuss them. But with that qualification, I'll just state, Mr. Murdoch, you've testified that the Bethany Reservoir alternative, which included the eastern option conveyance alignment, was discussed as part of the SEC meetings, correct?
So I guess to clarify that, the Bethany Reservoir alignment shares similar conveyance alignments as the eastern option. Is that what you're asking?
Okay, so there is an eastern option conveyance within the Bethany Reservoir alternative, correct?
I guess I view the eastern option as a separate option, and the Bethany Reservoir alignment is a separate alternative that shares some of the same alignment features as the eastern option.
Okay.
I do not consider those one and the same, if that's what you're asking.
Oh, well, it is. I misunderstood what you meant, so thank you. We were not saying the same thing. And I'm really just getting to you confirming this as background for a few other questions, but we'll see how it goes if my differing understanding is relevant here. So you have cited the consideration of the Bethany alternative as an example of the SEC input that was incorporated into the DCP design, correct?
That is correct.
And are you aware of any other factors or considerations other than SEC input that led DWR or the DCA to consider the Bethany alternative with Bethany Reservoir alternative with an eastern conveyance alignment?
I'm sorry, your audio is breaking up. Can you
I'm sorry.
clarify that question again?
Are you aware of any factors or considerations other than the SEC input that led DWR or the DCA to consider the Bethany Reservoir alternative with an eastern conveyance alignment?
So the last part of your statement there says with the eastern conveyance alignment, or are you asking, are there any other factors that?
Let's break it down a bit. Are there any factors other than the SEC input that led DWR or the DCA to consider an eastern conveyance alignment?
I guess since Miss Gwen Buchholz was part of that discussion, I'd like to ask her if she could answer that.
We did, the concept of using the Bethany Reservoir alternative was to try to do something that did not involve Bay and the connection to Southern Forebay to Banks Pumping Plant, because those facilities were located on areas that had a high density or higher density of biological resources, terrestrial resources that were of concern. And so one of the things we came up with is, what if we bypassed that area and went directly to Bethany Reservoir? Once we did that, there's a siting study that we looked at multiple ways to connect either the central alignment or the eastern alignment to the Bethany to what we call the Bethany complex, where the pumping plant is located, and subsequently the pipe or the aqueducts up to the Bethany Reservoir. So we really did try to see if we could connect the central, if it made sense to go to the central alignment to the Bethany complex or the eastern, and that's how we came up with it. But it was outside of the SEC, yes.
All right. The Bethany Reservoir itself, but what about the eastern option?
That's what I'm saying is, once we determined that we wanted to look at an option that had what we call the Bethany complex, where the pumping plant is, we then said, let's see in the siting study, should it connect over to the central alternative? Does it make sense to connect to the eastern alternative? So we did a siting study that looked at those different ways, plus a siting study of the locations of those connections. Basically, we did that to avoid having to build the Southern Forebay in areas with high terrestrial resources.
So
we didn't look just at SEC. We talked about this at SEC, but this was actually done not necessarily in connection with the SEC.
Okay, so shifting from the central corridor option to the eastern corridor option was not a decision that was based on SEC, exclusively on SEC input? Is that correct?
Not exclusively. No, we did present it at SEC and heard comments on it, but basically the connection from the central over to the Bethany complex would have affected more communities such near Discovery Bay in those areas. So that's why we went to the eastern alignment connection.
Okay, so the eastern alignment was chosen based on the effects to Discovery Bay?
Amongst many other things. The way we would look at the central connections, there was crossings of, I have to remember, but I believe it crossed Victoria Island. And there's different ways to look at it, but you'd have to pull up the siting study that we did and included as part of our EPR. And we also discussed that with SEC in September of 2020.
Okay. Thank you. Ms. Mullen, we emailed you the hearing office several exhibits and we did not give them exhibit numbers, but would like you to please bring up the exhibit that is titled January 2020 DCP Independent Technical Review Panel Report. If you can locate that.
We have them, so
Ms. Moskals, it was emailed by Ms. Moskal of our office.
Yes, and we have them.
Okay.
Can you repeat the title again, please?
Yes, it is January 2020 DCP Independent Technical Review Committee report. Is it titled in the PDF? It may have a slightly different title in on the face of the document. No, that is not it.
Miss Mullen, try the document that starts with January 2020.
That's most likely it. Thank you.
We'll get there. Be fair with us.
Okay, great. Thank you. You could just scroll down a little bit so the language in the introduction, but there you go. Why don't we get the header of it? So scroll up a tiny bit. I'm sorry, so we can see what it's about. Thank you. That's good. Mr. Murdoch, are you familiar with this document?
Right now I'm not. I would have to refresh my memory on this particular document.
Okay. To your recollection, did you ever read it?
I guess I was involved in some of the internal technical review panels that occurred, and I guess I would ask, is this one of the panels in which I reviewed the project with the team for a week?
So you were not a member of or involved with this particular panel?
I would need time to review this document to answer that question.
Okay. So let's, Mr. Murdoch, I still have some questions based on this, and let's try. If you could please review the second sentence of the first paragraph of the introduction, which says the report refers to it refers to the DCA and the DCO. Do you know what those acronyms refer to?
Yes, I do.
And what do they refer to?
So the DCA refers to the Delta Conveyance Authority, and the DCO refers to Delta Construction Office. Or the,
Thank you.
I'm sorry, it's not Delta Construction Office.
Delta Conveyance Office.
Delta Conveyance Office, thank you.
We use it every day.
And is that the Delta Conveyance Office within DWR?
Yes, it is.
Okay. Ms. Mullen, could you please scroll to PDF page 6? Think 6. Okay. And scroll down just below figure 3 to that highlighted language. Do you see that highlighted language, Mr. Murdoch? And could you please review the language in the first paragraph under figure 3, which starts the consensus among the ITR was that the central corridor is logistically impractical, and the ITR does not recommend this corridor be further studied. And let me know when you've had a chance to review that.
Okay, I've reviewed it.
Thank you. Are you familiar with this conclusion of this panel as described in this paragraph, Mr. Murdoch?
This was before my time on the project, so I am not particularly familiar with this conclusion.
Do you have an opinion, Mr. Murdoch, about the logistical feasibility of the central alignment?
Objection lacks foundation, vague and ambiguous as to whether or not these alignments are even the same alignments being referred to in this proceeding or in the EIR for the Delta Conveyance project.
I'm not asking about the EIR.
Can you,
Is Mr. Murdoch, is the highlighted, yellow highlighted line up in the figure 3 appear to you to be similar to the central alignment that is described in the EIR for the DCP?
Objection for speculation.
It's not speculation. Mr. Murdoch is the engineering expert, and he is here testifying about the design and the alternatives.
I think it's a fair question. Mr. Murdoch, you can caveat your response as necessary.
Can you scroll the document up so I can see the yellow alignment? And so, Ms. Tabor, your question is, does the yellow alignment represent the central alignment, or could you please repeat your question?
Is it the same as the central alignment that is evaluated in the DCP EIR?
I cannot say that it's the same without looking at the EIR and
Fair
comparing
enough.
these documents.
Does it appear to be similar to the location?
If I may, because at this time, as Mr. Murdoch said, he wasn't involved in this part of the study at the time. This is not the same as it is what was finally presented in the EIR or the engineering project reports. This is a previous version that we had early in the project because it still has the intermediate forebay included in the alignments.
Okay, fair enough. We'll move on. Let's go back to Mr. Murdoch's testimony, DWR1, please. And if you could scroll, Ms. Mullen, when you get to DWR1 to the top of PDF page 10, where it discusses minimize disturbance to existing land uses. Mr. Murdoch, do you have any personal experience evaluating land use impacts?
I guess, could you be more specific to the evaluation of the land impacts?
Do you have any personal experience evaluating impacts to existing land uses from construction?
Over my career, I have looked at a lot of pipeline corridors and land that's needed for construction. And so from that aspect, I have an understanding of the land that may be required for construction.
Okay. So when you are providing an opinion regarding the extent to which the DCP design avoids and minimizes impacts to local land uses, are you relying on your professional experience?
I'm relying on that as well as the documents that are submitted here as the exhibits. So, for example, the removal of the southern forebay that was part of the central and eastern alignment. If we remove that, that reduces a land disturbance. The decision to move to two tunnel launch shaft sites versus three, that would reduce land disturbances.
Okay, thank you. And how do you define minimize in the context of your testimony?
I guess I would, the way that I looked at it is if there was an alternative that reduced the land disturbances, then we could minimize that. I guess I might ask Ms. Gwen Buchholz if she has any insight on that.
No, that's exactly it. We looked at the array of each one of the potential disturbances, and in cases of land use, we identified alternatives or locations that would have less impacts to agricultural, recreation, and habitat community land uses.
And so is it correct, am I understanding you correctly, that in this context of your testimony, minimize means any reduction? Any reduction would constitute minimizing disturbance?
I guess when you say any reduction and minimizing, I guess anything that reduced the land use of one alternative compared to the other would minimize that land use.
Would you define it to mean reduce to the least possible amount?
That's actually vague as to what we're comparing the minimize to.
Well, as I understand, and I acknowledge it's not that clear, but as I understand Mr. Murdoch's testimony, he is talking about the ways in which, among other things, the project was modified from what had been approved in the California Water Fix to address community concerns as were expressed, at least in part, through the SEC process, and the ways in which the DCA and DWR sought to minimize disturbance to existing land uses. And so it's it doesn't make it clear, but since there is no disturbance to existing land uses, I assume there had to be some frame of reference, and so I'll put it in that context. My question in that context.
Objection that mischaracterizes the witness's testimony, which has nothing to do with water fix or comparisons to water fix.
Okay, so how about as to the any tunnel proposals that DWR had considered prior to developing the DCP?
Objection as to relevance.
I'm just trying to understand minimize. The witness has asked me to clarify what I mean by minimize, and I'm asking how he interprets it. If we can't go any further with this, fine. But just to refresh your memory, my last question was, would you define minimize as used in your testimony to mean reduce to the least possible amount? That was my question.
As we look at the construction site and the land that's needed, as I looked at the project, many of the sites are constrained, and I feel like the conceptual design for the Bethany Reservoir alternative has minimized that land use that is required. I would ask if Ms. Gwen Buchholz has any insight on that or would like to comment on that.
That's okay. I don't,
Well,
it goes beyond really the scope of what I was getting at. I was
Right,
asking
'cause-
for a specific definition. And so let's move on.
But if I could add, please.
Yeah.
Go ahead.
I'm sorry, Ms. Hearing Officer Kinsey, were you asking Ms.
I was
Buchholz to continue?
inviting Ms. Buchholz to expound if she wanted to.
Okay.
Right. We started with the alternatives that were in the notice of preparation published in 2020. And then we developed several other alternatives, including modifications to the central alternative and eastern alternative in that notice of preparation to try to minimize the effects on land use. One example was modifying the extent of some of the construction areas, like on and taking out the intermediate forebay, those types of things. So we were comparing it to what the notice of preparation started with, and developing the rest of the options after that.
Got it. Okay, so Ms. Buchholz, was the central corridor alignment modified based on the input of the January 2020 Independent Technical Review Panel Committee's report?
We reviewed that in the ITR, we called it the ITR report, as you can see, and we considered many of their comments. They were additional inputs from stakeholder engagement committee, and inputs from engineering, and inputs from environmental analyses by DWR. So yes, we did look at it. We didn't agree with everything, but we took a look at the report.
Okay, thank you. And in what ways, Ms. Buchholz, was the central corridor alignment that was included in the EIR different from the central corridor alignment that the ITR panel evaluated?
Well, one of that was early on. We still had the intermediate forebay. We attempted to make changes in access roads, and one of the ones we worked, I remember on, was the central alignment had a shaft on Staten Island, and one of the things we worked on was to move that shaft to make it less problematic to both the natural resource, especially sandhill crane habitat, as well as recreationists that use Staten Island. There were other aspects that they brought up from an engineering standpoint about access and accessibility from the equipment, and we looked at that to make any changes to see if we could move shaft locations around to be easier to access. And they also provided some information in their experience on foundations, as in all that's in their report.
Okay, so Mr. Murdoch, would you agree that the central corridor alignment as it was evaluated in the EIR was logistically impractical?
Objection asked and answered.
I'm sorry, I didn't hear his answer. If he answered that, I did not hear that.
I'll allow the question. Go ahead, Mr. Murdoch.
I would not characterize it as impractical.
Not logistically impractical?
I would not characterize it as not logistically impractical.
Okay. All right, well, let's move on then. Ms. Mullen, I would like to ask a question based on one of Mr. Brodsky's cross-examination exhibits. If you have access to those, it was HCC6. Are you able to pull that up?
You should be able to.
Okay. Okay, great. Thank you. You can maybe just scroll down or minimize a little bit. That looks good. Thank you. Just to refresh your recollection about this, Mr. Murdoch, the exhibit states that the siting, this refers to the DCP intakes, and it says the siting of the intakes is largely a regulatory process. Do you see that?
Yes, I do see that.
Okay, thank you. In what way was the siting of the intakes largely a regulatory process?
the citing of the or the regulatory process that that's referring to would be related to the U.S. Army Corps of Engineers and the Central Valley Flood Protection Board, and gaining approval of that. Ms. Gwen Buchholz, do you have any other input on other regulatory processes that were considered?
Yes, as we described in SEC, we talked about in the SEC committee meeting of January 22nd, 2020, is actually, we have an exhibit for DWR. I think the memo is 0008. We had a slide on, you don't have to bring it up, but we had a slide on page 214 where we also talk about it. It's a fisheries issue too. So because of the consideration by the National Marine Fisheries Service, U.S. Fish and Wildlife Service, and California Department of Fish and Wildlife, we looked at the fact of saying that we had to consider where we placed the intakes so that the outside bins had enough depth on them, a minimum of 12 feet of water, that we had 1 mile spacing between the intakes, and no sediment accumulation at those areas. Inadequate, the intake had to be straight. We couldn't make a curved intake because of the way the fish screens had to be designed, and that there would be negligible levels on effects on flood levels, as Mr. Murdoch said, associated with the concerns of the U.S. Army Corps of Engineers and the Central Valley Flood Protection Board. We also looked at any geotechnical concerns that they would have, and the concerns of Caltrans, which owns and operates SR 160, State Route 160 along this area. So we talked about these regulatory concerns in January 22nd, SEC.
Okay, thank you. That's helpful. Ms. Mullen, could you please pull up DWR 15? Thank you. This is the December 23rd, 2021 DCA intake site identification and evaluation memorandum. Mr. Murdoch, are you familiar with this document?
Yes, I am.
Okay, great. Thank you. So the document states that the purpose of this technical memorandum is to identify potential sites along the Sacramento River and evaluate them for suitability as candidate intake sites for the Delta Conveyance project. And if we can scroll down just a little bit to the background section, there is a reference in here to, thank you, right, that's perfect, that in the second sentence, that the previously identified intakes were established through a process that involves stakeholder representatives. Can you please define stakeholder as it's used in this sentence?
Many of the agencies that Ms. Gwen Buchholz just mentioned related to the regulatory agencies, I would consider those stakeholders. So Caltrans, Army Corps of Engineers, Central Valley Flood Control Board, other agencies that would need to provide input. I would consider those stakeholders.
Oh, I'm sorry to interrupt you. Please go ahead. Thank you. Did stakeholders include any local agencies in the Delta?
I would ask Ms. Gwen Buchholz that question, as this was before my time.
I wasn't involved in this technical team specifically, but I believe as we go further in that paragraph, there's a reference to Appendix A of this technical memoranda that was the Appendix F of that technical team's report. The participants in the fish facilities technical team may be included in that. Otherwise, I would have to bring up, that's where I would go look, but I was not specifically involved in this. This was part of the several year's process for Bay Delta, initially for Bay Delta Conservation Plan. I will tell you that we included this information in this technical memoranda for DCP because we felt that the information associated with the fisheries regular resource team members was particularly important for us to consider as we move forward in intake siting. And instead of that, we didn't feel that that would have changed that much.
Sure. Okay. So if I wanted to understand who the stakeholders were and whether they included anybody beyond the specific agencies that were cited by Mr. Murdoch or described the fish facilities technical team, is that answer somewhere in the BDCP California Water Fix final EIR EIS that's cited in this paragraph?
It would have been, and you may want to go back to Appendix A of this document.
Okay.
I don't remember right offhand.
Yeah, I didn't see that in there, but if you're not aware of any other specific locations where that information could be found, we can move on.
That's where I would have gone. The FFT meetings.
Okay, yeah, I'm not. I'm speaking not to the FFT, but to local public agencies.
Well, but I believe the sentence that you were referring to, the way I read it, was that the fish facilities technical team comprised of agencies, stakeholders, and consultant representatives. That this was not a technical team that was associated with Delta Conveyance Plan.
Understood. That is, I see your point. Thank you. Officer Kinsey, I have come to a point where I am switching topics, and it seems like a good point to take a break if you think this is the right time.
That seems like a good idea. Thank you, Ms. Tabor. My proposal will be to break until 1 o'clock, but before we leave, are there any other matters we should address? And I will invite all of you to stay in the room if you would please, and we will reconvene at 1 o'clock. Thank you. It's 1 o'clock. Welcome back after our lunch break. I will turn first to our court reporter. Are you ready for us to go back on the record?
Yes, ma'am.
Thank you. And with that, I will just reorient us. This is the afternoon of the evidentiary hearing. It's April 9th of the evidentiary hearing on the proposed Delta Conveyance project. We left off with cross-examination of DWR's panel 5, and we have Ms. Tabor cross-examining. I think you'd mentioned, Ms. Tabor, that your colleague, Ms. Shorrock, would have questions after you. So I would ask my team now if you would please bring Ms. Shorrock up as a panelist. You might as well take care of that. And Ms. Shorrock, you're welcome to go ahead and turn your video on and give your introduction, please.
Hi, my name is, oh, you want to mute yours real quick? Sorry. My name is Casey Shear. Are you muted? Oh, you have to. You have to turn off your volume. Thank you.
It sounds good now.
Sorry about that. My name is Casey Shorrock. I represent Sacramento County Water Agency, Sacramento Area Sewer District, and Byron Bethany Irrigation District, and I'll be examining Mr. Volk primarily.
Thank you. Welcome, Ms. Shorrock. And I see we have Ms. Carroll, and we have our 3 witnesses and Ms. Tabor. So with that, I will hand things back to you, Ms. Tabor.
All right, have we corrected our audio problem?
It sounds good to me.
Okay, thank you. Sorry about that. Welcome back. Thank you. Ms. Mullen, could we return to exhibit DWR1, please? If you could please pull that up and scroll to the top of PDF page 14. Actually, correction, if you could go to PDF page 11. Sorry about that. I've been editing my reducing my questions based on what's been covered before, so I'm a little out of order here. Okay, great, thank you. Starting with Mr. Murdoch. Mr. Murdoch, in your testimony here in paragraph 25, you state that during construction, effects on land uses would be minimized by generally restricting most construction to weekdays and daytime hours. And you cite to exhibits DWR 18 and 19. Do you see that?
Yes, I do.
Okay. And are these the draft engineering project reports for the Bethany Reservoir Alternative and the Central and Eastern options, if you recall?
Yes, they are.
Okay. And have these reports been finalized?
They're considered final draft.
Okay. So what can you explain? What does final draft mean?
I cannot explain the details of that. That's just the status that they've been put into. You'd have to ask.
I'm sorry, who would I have to ask? My volume.
Maybe Miss Gwen Buchholz, can you provide any insight to that?
The reason that we identified these as final draft was because we recognized in the reports that we were still awaiting information such as geotechnical information, topographic surveys, information from landowners and others as we gained access to properties. And so we felt that this conceptual design could not be considered final unless we had all that information, which will be developed in future design. We'll probably never finalize this document because it'll be moved into the next phase of design.
Okay, that's helpful to know. And the versions that have been submitted with your testimony were completed in 2022, is that correct?
In most cases, the versions are 2022. Some were updated in 2023 with the final EIR.
Okay, but to your knowledge, these exhibits have not been updated.
No, if
Right.
their dates are specific.
Okay, thank you. Do Mr. Murdoch or Ms. Buchholz, can you provide page number citations where the construction limitations that are discussed in paragraph 25 are discussed in these engineering reports, DWR 18 and DWR 19?
I need to pull these up quickly to do that. I don't have them off the top of my head.
Okay. And part of the reason I ask is that the documents that DWR provided to the AHO, as far as I can tell, are not searchable. So I could not, I wasn't able to locate this language in these exhibits, and I was hoping you could point us to the specific pages that support this statement.
Certainly understand the concept. I have to check them out. I just don't remember the pages that we have on this. If one of them is, if we could pull up number DWR-00018, like to the table of contents, I can bring this to you because you're looking for the, let me make sure before we move there. Are we looking for the information that's described on line 7 through 8?
Yes, I'm looking for the information that is supports the statement, the sentence that begins on line 7 and ends on line 8.
The fact that we're looking for the daytime, that it's going to
most construction, generally restricting most construction to weekdays and daytime hours.
Okay, I just wanted to confirm what we were looking for before I sent us off on a wild goose chase.
Yeah.
So I think with that, Ms. Mullen, if we can pull up DWR 00018, please. And then scroll to the table of contents. And then I will hand over the navigation to you, Ms. Buchholz.
Okay. Also looking at my, yes, unfortunately it's not in the table of contents. Let me get to the point here. Give me 2 seconds. If you could go to PDF page 173, this is on this, yes, this is the CE. Please go to page 173. Oh, maybe it's not on page. PDF page 173. Oh, keep going down. That's what's the problem. Same page, just keep going down. So what, you could stop here. There's a subtable in the narratives for each of the physical features that are being looked at. And so you can see in this construction hours is pretty typical of many of them. That's why I went to this one. So we have, this is a tunnel as well as the trimmy slab construction. And this would happen at the shafts or at the intakes. So if you want to look at intakes, we could go up a ways. Which location were you looking
That's
for?
okay. I'm just interested in the first sentence about the construction hours. That was, so this is, thank you for bringing us to the exact language, or close to the exact language.
Right.
So this construction hour first sentence says most construction would occur 5 days a week from sunrise to sunset, assumed to be approximately 10 hours on average. What do you mean by most? How is that defined here?
So as you continue down in that same box of the table, the same cell, we talk about if we have concrete trimmy slabs, which are the very thick slab of concrete at the bottom of, in this case, the tunnel launch shaft. We have similar ones at the tunnel reception or maintenance shaft at the intakes. And we also have it at the bottom of the intake. They're very thick, tens of feet, and they have to be poured continuously. We can't stop and then pour another set of concrete on top where it won't connect well, right? So when we pour trimmy slab, we have to do it for 24 hours as we go forward. The other thing, this one's another one to pick from, is that the tunneling, we would do tunneling at the tunnel launch shaft sites, one at Twin Cities Complex and one at Lower Roberts Island. And they would go for 20 hours a day for 5 days, for the Monday through Friday, 5 days a week. And then we'd have some equipment maintenance that could occur on, it's on Saturday. We have someplace in the rest of the document we say that. I would point out to everyone that there is no drying and testing. This is only an example of the type of thing we use on this alternative. The final Bethany alternative did not include drying and testing.
You're referring, excuse me, Ms. Buckles, may I ask you to clarify, there's no RTM drying and testing proposed?
Oh, there's testing.
In it?
I'm sorry, there's testing that would occur, but no drying. I apologize.
Okay.
That was my mistake. I got ahead of myself. There is
sorry
testing.
to interrupt you there, but
no, very important. I'm glad you did, because I totally misstated.
Okay. And just to clarify,
and one more thing, that since this completion of this document, in the environmental impact report, there's been further limitations on the construction, so that we could no longer, we could only work from, we both have the daytime issue, but sunrise to sunset. But for instance, in the summer, sunsets a little later. The EIR restricts most of our work from 7 a.m. to 7 p.m. or all of our work from 7 a.m. to 7 p.m. if it's not more restrictive at certain sites due to biological resources.
Okay, thank you. So the 7 a.m. to 7 p.m. Limitation is not limited to pile driving, is that correct? It's all surface construction activities?
Yes, except for, as we say here, the trimmy concrete pours and the tunneling and the associated RTM testing.
Okay. Okay. Thank you. Let's give me just a moment here I'm trying to see how much I can reduce my questions based on things I've been asked before. Let's go, Ms. Mullen, if you would please bring up DWR 1101. Thank you. And if we could scroll to page 4, please, to the top. A little down a little bit to this might have printed out in a different, I printed it, let's go to permit where it says permit term, section 3, construction water right permit terms, permit term 10. So if you scroll up a little bit, the pagination must be different. There we go. Somehow it's different on my one that I printed from the website. Thank you. Yes, I guess this question goes to Mr. Murdoch in the first instance, but yesterday, Mr. Brodsky asked whether DWR, would be willing to commit to a permit term that would limit construction hours. And Ms. Morris stated that DWR's proposed permit terms included limitations on the hours of construction. And Mr. Murdoch, could you or anyone else in the panel point me to where in this document the construction hour limitations are described? And if there are no, if you're not able to identify any construction hour limitations, that's fine. Please, you can just tell me that.
As of right now, I'm not able to identify any.
Okay. Ms. Bolkowitz, same question to you.
I cannot see anything at this point in time. I may be missing something though.
Okay. Let's scroll to PDF page 6, please, Ms. Mullen. Permit term 19. Oh, I'm sorry, my pagination is off. Let's scroll up to permit term 19. Okay, so do you see this term, Mr. Murdoch?
Yes, I do.
Read it. Okay.
Yeah.
So this term references limiting construction outside of daytime hours, minimizing new light by limiting non-tunnel related surface construction after seasonal daylight hours is the language that it uses, and it refers to the final EIR mitigation measure AES 4A. Does DWR, to your knowledge, Mr. Murdoch or Ms. Buchholz, have a definition of the term limiting as it's used in the context of this permit term and mitigation measure AES 4A?
I would ask Ms. Gwen Buchholz.
So I did, first of all, I apologize that I missed this when you asked the previous question for the timing. Secondly, what we looked at is sunrise to sunset in the documents. And as I said, subsequently, before the final EIR, that was limited in Medicaid to 7 a.m. to 7 p.m. So if 7 a.m. occurred before sunrise, then sunrise would be the critical factor. And if same kind of situation, if in the summertime, if you didn't get sunrise or sunset till 8:30, we would still stop at 7 p.m. except for the trimming concrete pours, the tunnel boring machine, and the associated moving of RTM into the testing basins at the tunnel launch shafts.
Okay, thank you. And I apologize, but I did have trouble following some of the cross-examination that covered this already. Can you please remind me which of the EIR mitigation measures includes that particular limit of sunrise to 7 p.m.?
Yes, I need to bring that up. Sorry. I don't have it in front of me. It's an AES. No, that should be under the AES because it's to this. I believe it's either under aesthetics or it's under.
I think it's needed. I'm not sure.
The
so
terrestrial. So there's several places in the biological mitigation measure -21. There's also, we have multiple situations there. That was the primary thing, but we also had one, I believe, in the aesthetics for visual on that too. This was also, that's another biological one. Because many of these species are at every construction site. From the engineering standpoint, we've just adopted it throughout the project. I think we had them all in the biological areas.
So if I were to be looking for an EIR mitigation measure that had a firm commitment as to the limitations for surface construction activity hours, excluding the concrete tremie pours, I would look at a suite of mitigation measures or one in particular?
No, the suite of the numerous ones in Chapter 13 of the terrestrial resources.
Okay. And those would apply even in urban areas in the town of Hood?
Yes.
They're not limited to?
No, they weren't limited
okay.
in that department because many of the species were avian and they would occur even in the town of Hood communities.
Okay. All right. I appreciate that. Thank you for answering my question about noise. I do have a few questions next.
Well, that was
regarding...
more light. That was light. I didn't answer noise. I answered light.
Oh, okay. So, but they relate to construction
yes.
activity that could generate noise.
Technically, yes.
Okay. I'm sorry to interrupt you. Any
No, I just
let's
wanted
move
to say
on.
I didn't answer a noise question.
Okay. Thank you for clarifying that. Let's, Ms. Mullen, if we could please go back to Mr. Murdoch's testimony and go to PDF page 20. And this, I'd like to ask some questions, Mr. Murdoch, regarding the management of reusable tunnel material. Could you explain your definition of reusable in this context, Mr. Murdoch? How do you define reusable tunnel material?
So the reusable tunnel materials, the material that comes from the tunnel excavation, that material will be reused at the launch shaft sites to fill some of the borrow areas that are used for construction, and then it will be stockpiled on the site.
Okay. And what do you have an estimate of the volume of tunnel material, I guess to use your term RTM, that will be produced in constructing the DCP?
I don't have the estimate on the top of my head right now, but if you were to look at DWR Exhibit 23, that would likely contain estimated volumes.
Okay. Does it sound correct to say it's over 14 million cubic yards?
I guess I would like to look at that exhibit.
Sure. Well, let's
if we
just,
could.
sure. Ms. Mullen, I actually, the basis for my question is an exhibit that we emailed last night, and it's titled DCP Section 404 Application Continuation Sheet from 2022. Thank you. Mr. Murdoch, are you familiar with this document?
Not particularly at the moment. I'm not.
Okay, well, let's just scroll, Ms. Mullen, if you would, to the top of PDF page 21. And if you could review in the last two sentences of the first paragraph, Mr. Murdoch, where it says the proposed project is expected to generate 14.4 million cubic yards of wet excavated RTM.
Yes, I see that.
Okay, so does that, do you agree that that's approximately the amount of RTM that is expected to be generated from the tunnel construction?
Can you tell me what's the date of this document?
It was submitted in support of your the DCP 404 permit application, and I believe it is 2022, but I'm not sure. I don't know when exactly you submitted the 404 permit application. But if you don't know, you can just tell me that you don't know the amount of whether this is correct or not.
I would rely on the exhibit number that I cited before to confirm the numbers.
Okay, well, before we ask Ms. Mullen to bring up something else, I think, let me try this, save some time. Do you have an estimate, Mr. Murdoch, of the percentage of the RTM that will be produced by the DCP that will be used for the on-site for refilling excavated areas?
Objection calls for speculation.
Well, he's the engineering site manager, so I...
Overruled, I'll allow the question. Go ahead, Mr. Murdoch.
So All of the RTM material stays on site at the launch shafts.
And how much of that, I'm interested in how much of what is on site is used to refill excavated areas as opposed to just stockpiled?
Well, if you'd give me a minute, I will pull up the exhibit that I referenced, and I could probably find that information for you if you'd like.
If we can do it quickly, sure.
So that was exhibit DWR 23.
Okay.
I guess I'd invite Ms. Gwen Buchholz to chime in if she's finding it. But if you go to, I believe if you go to PDF page 9, there are summary tables.
So,
If you-
Mr. Murdoch, oh, sorry, go ahead if you.
Oh, I was going to ask to scroll to the bottom of this table. So for example, at the Twin Cities site, at the bottom of that table, it indicates surplus RTM stockpile at Twin Cities site was approximately 4.7 million cubic yards.
And this total is based on the assumed amount of that would be what's left over after the amount that's used on site to fill excavated areas. Is that correct? It doesn't assume it. Sorry.
Yeah, I would need to study these numbers in more detail to confirm how much is in borrow versus what's stockpiled on site. But based on the information that's in the bottom of this table that indicates surplus RTM stock material at Twin Cities on site, I would say that there's 4.7 million cubic yards of material that is stockpiled on site at Twin Cities.
Okay. And is that the only location where there would be RTM stockpiled?
Lower Roberts Island site would also have RTM material that's stockpiled.
Okay. And does this document provide information about the estimate of the stockpile amount of RTM at Lower Roberts Island?
Yes, if you go to the following table, you can table 2-4, and on the next page.
Okay. So if I'm reading this correctly, it says approximately 4.463 million cubic yards.
That's yep, that's
okay.
correct.
Okay, thank you. I apologize, Ms. Mullen, for making you switch back and forth, but if we could please just return to Mr. Murdoch's testimony, DWR1. and go to page 20. Actually, no, I'm sorry about that. Can you please go back to the exhibit that we were on previously that I provided, the 404 permit application document? Thank you. Okay, great. And to again we're on page 21. Thank you. Sorry for the confusion. Mr. Murdoch, other than the RTM that's used to backfill, or let's say not a correction, other than the RTM that is going to be used on the tunnel shaft sites, how confident are you that the remaining stockpiled RTM can be reused?
As the material, I guess, are you referring to if the material is hazardous or not? Because the material will be tested as it comes out of the excavation. So we're talking after the material's been tested.
Sure. Well, we can get to the hazardous testing, but overall, maybe I should rephrase my question. Do you have an estimate of the amount currently of the amount of stockpiled RTM that will be capable of reuse?
The estimate would be in the soil balance document that we just looked at.
Okay,
So
well, I don't think we need to go back to that right now. That's fine. Thank you for telling me where to look. Is the determination as to how much, whether RTM can be reused or not, will be dependent on the results of hazardous material testing. Is that correct?
I was trying to clarify when you were talking about the material that would remain on site. Once the RTM hazardous material testing is complete, then it can be moved and stockpiled on site.
Okay. So do those numbers that we looked at in DWR 23 include any assumptions about the results of hazardous material testing?
I would have to further examine that document. Maybe I might ask Ms. Gwen Buchholz if she has insight to that.
We did, and I don't want to misquote a number, but we did assume that there would be a certain amount that we may have to move off-site because of potential hazardous. I just don't want to. It's a very small number, but we did include that. With respect to reuse, if I may, it may be helpful. Not sure. We did not analyze any specific reuses of the RTM in the development of this document, mainly because that would be a subsequent project that we didn't have anything defined in detail at this point in time. There were some people at stakeholder engagement committees that said, could it be used for levee repair? On the other hand, we had several people that said, shouldn't be used for levee repair. So with respect to that, we decided not to include, we just stockpile it. And if there was something subsequently down the line, that would be a different project. And there would have to be a lot of analysis. The document also, EPR and the EIR, discuss a field investigation in the future design phase that would look at taking some reusable tunnel material from a different tunnel site or from the geotechnical investigations on this project and look at the soil composition and structural capabilities of that material to determine if they might be used on other sites in the future. But there's nothing defined now, but there is a potential for reuse. There just hasn't been anything defined.
Okay, thank you. So as of today, DWR doesn't have any evidence that the RTM will be capable of being reused.
That was not
Objection, vague and ambiguous as to what it would be reused for if we're talking about other uses or for project uses.
Does DWR have any evidence at this time demonstrating that RTM that is not used for DCP purposes can be reused for any other use?
That was not analyzed, no.
Okay, thank you. And to make sure I understand, Ms. Buchholz, how you described it, the numbers that Mr. Murdoch referred us to in DWR 23, which were total amounts of RTM at the Twin Cities and Roberts Island launch sites, were those amounts adjusted to reflect a certain amount of assumption about a certain amount of hazardous waste contaminated material that would need to be removed from the launch sites?
Yes.
Okay, so that would be sort of a net number, net.
Yes.
Okay.
So it's a net number from generated at the tunnel boring machine, amount that would be used to refill borrow pits that were used to make tunnel shafts, and anything that we'd have to move offsite for hazardous waste.
Okay, I appreciate that explanation. Thank you. If we could look at the Mr. Murdoch, the first sentence of the second paragraph in this 404 permit application states that RTM would be placed in temporary stockpile areas. And how did DWR define temporary in this context?
Objection, lacks foundation. The witness already said they were not familiar with this document.
I think that's fair, Ms. Tabor. Do you want to raise the question?
If RTM is not reused, would it remain permanently on site at the tunnel launch shaft sites?
So I think, as I stated earlier, the RTM material does remain on site at the Twin Cities site and the Lower Roberts Island site.
Okay, that's fine. Thank you. Returning to your testimony, Mr. Murdoch, on page 20, Ms. Mullen, DWR 1, page 20, lines 15 through 17, if you could scroll down a little bit about that. You discuss hazardous materials in relation to RTM. What types of hazardous constituents may be found in the RTM generated by the DCP construction?
I'm going to let Ms. Gwen Buchholz answer that.
One of the technical memoranda that we prepared looked at potential for that based upon the limited geotechnical information that we have at this time. And we looked for certain things we looked for what was listed by the California Department of Toxicity, things that we looked at for the Regional Water Quality Control Board for the Central Valley. Would be considered hazardous under those capabilities, EPA listings. And from the limited geotechnical information we had, we did not see any of those. But those were the things that we analyzed at this point in time. There'll be a complete, as there would be for any excavation, looking at the whole suite of analytical testing would have to be happening. That's why it will take over a week. We would store it for a week to allow that testing to be completed.
Okay, thank you. So Mr. Murdoch, you state that if any hazardous material let me correct that, that hazardous material will be transported to licensed disposal locations. Has DWR identified specific disposal locations where RTM containing hazardous materials could be transported?
I do not believe they have. I would ask Ms. Gwen Buchholz for any clarification.
Not at this
Okay.
surveys of that.
Thank you. Mr. Murdoch, on lines 18 through 20, you state that water drained from the RTM will be treated on site. Do you have an estimate of the volume of water drained from the RTM that will be generated?
Yes, I know that the engineering project reports do have estimates. I do not know what those numbers are right now.
Okay.
If I may, actually, we have not calculated that volume of water at this time. But it'll be collected under when the tunnel material comes out. That's actually the temporary storage, and it'll be in lined basins. And while the testing's going on, that water will be draining and will be collected and will be subjected to full treatment so that that water can be reused on site for either tunnel boring machines, dust control, that type of thing.
But does DWR know, have any information today regarding the types of constituents that you might expect to be present in the water that's drained from the RTM?
The only thing we have would be right now associated with what we found in the geotechnical investigations, a few geotechnical. We didn't do it on everyone, just a handful. And that will have to be part of design. And especially as we get more geotechnical information and look at the constituent, or look at some quality issues on those. We do some water quality testing as we do more geotechnical investigations.
Thank you. Has DWR identified a specific method of treatment for RTM water?
Not at this time, but we anticipate that all water that would be collected this way will have to go through some type of treatment, and it may change as we move along the tunnel boring machines or tunnel alignment.
Okay. Thank you. Ms. Mullen, could we please go back to one of Sacramento County's exhibits, the January 2020 DCP Independent Technical Review Committee report that we started with earlier this morning. Thank you. And scroll to the bottom half of PDF page 10. Okay. Here, there we go. Great. Thank you. Mr. Murdoch, could you please review the first two sentences of the first paragraph under section 4.2 titled Tunnel Material? And let me know when you've had a chance to review that.
Yes, I've reviewed it.
Okay. So this report, DCA DWR report concludes that soft ground tunnel material is not a commodity in that it has no residual value and is difficult to dispose or find a use for. Do you have any reason to disagree with the expert panel's conclusion on this point?
I guess I would state that I'm not familiar with this document based on just that limited sentence right there. The scope of what they might be wanting to use the material for maybe was narrow, or I guess I don't feel like the RTM material could not find a use somewhere else.
Do you have any personal experience involving construction projects that generate soft ground tunnel material?
Yes, I do.
And in those instances, did the tunnel material, was it reused as a commodity?
The material can be reused depending on the application. If you're looking for fill material that might want to be used for future construction, that material can be dried out and compacted and put in place as a fill material.
When the independent technical review panel states, based on their experience, that it's difficult to dispose or find a use for soft ground tunnel material, would you agree with that statement?
I think if you would want to immediately reuse it, I would assume that they're referring to the time required to dry the material out and recompact it.
But you don't have any personal experience with this panel to support that assumption that you just described, correct?
Yeah, and I don't have any personal experience with this panel and understanding how they drew the conclusion of the sentence that you've highlighted there.
Fair enough. So just to conclude this discussion about RTM, if the RTM cannot be reused or on-site or off-site, it would be left in place at the launch sites, correct?
Objection asked and answered.
I'll allow the question. Go ahead, Mr. Murdoch.
Yes, I guess as I've stated before, that material will be left at the launch shaft sites.
Thank you. Ms. Mullen, could we please scroll to the top of PDF page 11? Thank you. So, Mr. Murdoch, this technical report here discusses the tunnel's classification as gassy or potentially gassy. Do you have any experience working on a tunnel project that involved the risk of an explosion from gas?
Objection lacks foundation. Again, the witnesses said they are not familiar with this document, and we are unsure of what tunnel alignment or tunnel it is specifically analyzed.
Fine. It does. The report does describe the central and eastern alignments and includes a figure that we did review that showed their general location. And it describes, based on what is known of the geology, it's anticipated the tunnel will be classified as gassy or at least potentially gassy.
I'll allow you, Ms. Tabor, we can go down a little bit. I think your first question for Mr. Murdoch was whether he had experience with these types of conditions. Was that right?
Yeah, working on a tunnel project that involves the risk of an explosion from gas.
Go ahead, Mr. Murdoch.
For the type of tunnel that we're talking about here, I would rely on the subject matter experts of my engineering team to provide that experience. I do not have experience with gassy soils with this type of tunneling that we're talking about.
Okay, thank you. That's fair enough. The second paragraph, we could scroll down just a little bit, section 4.4, thank you. This highlighted paragraph refers to an advantage of moving the alignment closer to Interstate 5 to facilitate rescue attempts. Do you see that?
Objection lacks foundation. I'm just going to raise again that Ms. Buchholz already testified that these alignments were not consistent. I'm not putting words in her mouth, but she's already testified that these are not the same alignments.
I'm not asking about the.
So I'm objecting again as to relevance.
Noted, and we can raise it as a standing objection with respect to questions related to this document, but I'll allow, go ahead, Ms. Tabor, you can ask your questions here.
Yeah. So would there be a health and safety risk to Delta residents if there were a gas explosion in the DCP tunnel or a shaft?
Calls for speculation.
Overruled.
If I may add something, in DWR, believe it's 00018. It's the narrative for the Central Eastern Engineering Project Report on PDF page 117. This was a report that was we have the DCP or the engineering report acknowledged that because of the geology, the tunnel would be classified as, it could be classified in some places non-gassy or potentially gassy or extra hazardous. We won't know this until we gather some more we have to do some specific field investigations in a manner that we can capture the gases as we do the geotechnical field investigations. If there are methodologies that, as we say in that page, on page PDF page 117, that we talk about how we would design in a certain manner to prevent or adverse situations.
Okay, thank you, Miss. Thank you, Ms. Buchholz.
So I just want to say it was looked at. Yes.
Thank you. Okay. So could there be, just going back to my question and rephrasing it slightly, could there be a health and safety risk to Delta residents if there were a gas explosion in the tunnel or a shaft?
Objection calls for speculation.
Overruled.
Well, Mr. Murdoch is an expert in tunnel.
I overruled the objection, Ms. Tabor. Thank you. Go ahead, Mr. Murdoch.
To be able to answer that question, there's a lot of assumptions that would have to be made and have to clarify where the explosion occurred, where it was located, and matters of that fact. So it's difficult to give a yes or no answer on a question like that.
Right. So I understood, but I'm not hearing you say there could not be a health and safety risk if there were a gas explosion in the DCP tunnel or shaft.
There
You can't
could
rule
be,
it out.
right. There could be a risk, and especially a risk to the workers.
Yes. Okay. That fair enough. Thank you. Let's see. I'm hoping not too many more topics to cover here. Ms. Mullen, can you please pull up DWR 10, which is the SEC member question comment tracking master log, and scroll to PDF page 44. Mr. Murdoch, you cited this in your testimony. And this is a very hard to read, but if you could maybe zoom in, Ms. Mullen, so we can see the response. Thank you. Okay. Mr. Murdoch, could you please review the question and response? Oh no, can you scroll down a little bit just so we get the first line of this table clearly in view, everything that's there? Yes. Okay, that's good. That's enough. Can you just review the first the question and response in the first row on this page? Each one begins with the ITR report. And let me know when you're done.
If you'll give me a minute. Yes, thank you.
Yes, yeah, just let me know when you're done. All right, still reading.
Yes, I am. I'm making sure I understand it.
Okay, sure, no problem.
So I finished reading it. I guess as I read the question and the comment.
Well, I don't
questions
have a
pop-
question yet unless you're unless you don't understand what the document is. I was going to,
Yeah.
I just wanted to make sure you read it, and then I was going to ask you a question. So
I guess I was gonna make a comment to the question that is written there is
I don't have a question about the question.
Let's let Ms. Tabor ask her question. We'll start from there. Thank you, Mr. Murdoch.
Thank you. So this exhibit, which is referenced in your testimony, Mr. Murdoch, states that according to the U.S. Geological Survey, there's a 72% chance of a 6.7 or greater magnitude earthquake in the Bay Area by 2043 that could cause delta levees to fail. Do you have any reason to disagree with that statement?
I do not.
Okay. Are you aware of any other evidence regarding the earthquake risk that could cause delta levees to fail? Beyond the USGS survey that's quoted here?
Other risks beyond seismic risks that
Other studies, any other risk assessments regarding the probability of an earthquake in the Bay Area that could cause delta levees to fail?
I could not cite one right now. However, I know that this is a seismic area. I mean, California is considered a seismic active area.
Okay, thank you. Ms. Mullen, if you could please pull up the exhibit that we emailed to you that is titled Delta Independent Science Board Comments on FEIR. And please scroll to PDF page 6. Thank you, that's good. If you could scroll up just a little bit more so that we can see the seismic risks may be overstated at the top. And I would ask Mr. Murdoch first, are you familiar with this document, Mr. Murdoch?
I am not familiar with this document.
Okay. Ms. Buchholz, are you familiar with this document?
I'm aware that they've written documents like this, but I have not read this document.
Okay. Let's see if we have anything more to say about this. Let's scroll. I'm trying to avoid having to have you read the entire thing since you're not familiar with it. Can you scroll down a bit to where we says this in the first paragraph, this probability applies in reference to the, I'm directing you, Mr. Murdoch, to the sentences that say in their comments where they say the primary issue is the EIR's reference to the U.S. Geological Survey. And they characterize the DIS, Delta Independent Science Board's concerns that the EIR discussion of the seismic hazard in the Delta is misleading. They say that.
Is it possible to move I think it's scrolling, we're hiding what was.
Okay, so we need to scroll up a little bit. Yes, okay. So we can see the whole paragraph here. Why don't you just review that paragraph, please? Because I do have a question about it.
The first paragraph?
Yeah, the one that begins Delta ISB remains concerned. Okay. And when you're done with that paragraph, Mr. Murdoch, let me know, please.
Okay, I'm done.
Okay, thank you. So the Delta Independent Science Board in this, their comments on the final environmental impact report for the DCP cites, and in this paragraph, references a DWR investigation dated in 2008 that according to the Delta Independent Science Board, concluded that the risk of seismic rupture on faults in the Delta was much lower than major Bay Area sources. Are you familiar with the DWR 2008 study, which the DISB calls the Delta Risk Management Strategy Investigation?
I am not. Maybe members of my engineering team are, but I am not familiar with that study.
Okay. Ms. Buchholz, are you familiar with that?
I am familiar with it, but I didn't participate in it, and I've read only portions of it.
Okay. Was that investigation, I guess, is it correct to say then, if you're not familiar with it, that investigation was not presented to the Stakeholder Engagement Committee?
I do not remember speaking about this publication at Stakeholder Engagement Committee.
Okay, that's fine. These comments, Mr. Murdoch, also state that the potential, what the DISB characterizes as a potential overestimation of seismic risk may distort the project's potential benefits. Do you agree that the degree of seismic risk is relevant to assessing the project's potential benefits?
I guess, could you clarify that a little bit? Like should, I guess when I hear that, we should always consider seismic risks, or could you ask that again?
Okay. Does is the degree of seismic risk relevant to consideration of a project's benefits? If the seismic risk is it whether it's very low or very high, is it relevant to assessing the project's benefits?
Objection assumes facts not in evidence, assumes there's only one benefit for the project.
It does not assume. That's not my question, Ms. Morris. I'm just asking whether seismic risk is relevant. I didn't say to the exclusion of any other benefit. And I'm particularly interested in his opinion about the degree of seismic risk.
Go ahead, Mr. Murdoch.
So the degree of seismic risk as related to the benefits is what you're asking?
Correct.
So are you asking, would if the seismic risks were higher, would that change the potential benefits of the project?
I'm asking, I didn't ask that, but how about if I rephrase it? If the seismic risks were very low, would that be relevant to an assessment of the project's potential benefits?
I guess as I think about that, there's many factors that would play into the overall benefits of the project beyond just the seismic risk.
Understood.
Yeah.
That has DWR cited seismic risk as and specifically the seismic risk noted in the Stakeholder Engagement Committee document that we reviewed, the DWR response that was attached to your testimony as a factor, an important factor justifying the DCP.
Yes.
Okay. Thank you. I don't have any further questions for you for this panel. At this time, I will mute myself and turn it over to Ms. Shorrock.
Thank you, Ms. Tabor. And Ms. Shorrock, you're welcome to come on camera. And I will hand things over to you.
Can you hear me?
Yes.
I am having a hard time with my audio. Would you give me one moment, please, to try and fix this? Okay, can you hear me now?
Yes, we can hear you fine.
Perfect, much better. Thank you so much. Okay, my questions are initially going to be for Mr. Volk. And thank you for being here today and answering our questions, Mr. Volk. Apologies if I let a couple of coughs slip out. I'm still getting over a long-running case of bronchitis. Ms. Mullen, would you please bring up Mr. Volk's testimony, Exhibit DWR 700? Thank you. And would you please scroll to page 4, paragraph 9 of Mr. Volk's testimony? Thank you. Great. Mr. Volk, in paragraph 9, lines 3 to 4, you state that the ambient sound levels were measured by ICF at 2 sites near the community of Hood in fall of 2020, correct?
That's correct.
Okay. And these are the only 2 ambient sound measurement sites located in Sacramento County, correct? That were taken for DCP EIR?
Yes, that's correct.
Okay. Ms. Mullen, would you now please bring up Exhibit AHO 1183, please? PDF page 11. And I'll be referring back to this quite a bit, so you might want to just keep it up. Thank you. On PDF page 11, we see a graphic. This is figure 24-2. Mr. Volk, this is the DCP EIR noise analysis chapter, and I'm assuming you're familiar with this chapter?
Yes, I prepared it.
Okay. Then you are familiar.
Yeah.
So figure 24-2 shows the general locations of these ambient noise measurements, of all of the ambient noise measurement sites, correct?
Yes, that's correct.
Okay. And is it safe to say that maybe it's a little difficult to determine where exactly these measurement sites are located near the community of Hood? If we want to zoom in, Ms. Mullen, on the Hood portion of it, where it says Hood up there at the kind of towards the top. You see those 2 green dots. Would you agree that it's hard to tell exactly where those are located from this figure?
Yes, there are 2 green dots near the community of Hood. What that represent locations where measurements were collected.
Right. But it's from this image, it's kind of hard to tell exactly where in that community they're located, correct?
Well, the figure is zoomed out to show the entire extent of the Delta Conveyance project area and the locations, so that we could fit them all on one figure. And yeah,
Understood. Well, I want to drill down on these locations a little bit. Appendix 24D of the EIR actually provides more information on these locations. Ms. Mullen, would you now please bring up AHO 1187, please? PDF page 2. And that will be Appendix 24D of the DCP EIR. And this contains sound level measurement field data sheets. And I presume, Mr. Volk, you're familiar with this appendix?
Yes.
Great. On the page we're looking at, we see the latitude and longitude for measurement site M01A, along with a hand-drawn map, correct?
That's correct.
Okay. And Ms. Mullen, would you please scroll down to the next page, PDF page 3? Thank you. On this page, we see the latitude and longitude for measurement site M01B, along with a hand-drawn map also, correct?
That's correct.
Okay. So to verify that these locations are indeed located near the town of Hood as you testified, I used these coordinates and the hand-drawn maps to determine that M01A and M02B are located to the south of Hood Franklin Road, with M01A further west near the river and M01B located further east closer to the canal. Is this your understanding of these locations, these measurement site locations? Mr. Volk?
Objection, lacks foundation.
I'm just trying to confirm locations of measurement sites in the EIR.
Let me ask this way. Mr. Volk, do you have an understanding of where these locations are?
Well, as you represent them, I mean, I accept your representation, but I mean, their coordinates. I would go back and look at them to be able to say specifically, but your representation sounds reasonable. Yes.
Okay, fair enough. Thank you. Ms. Mullen, yesterday I submitted something I labeled Sacramento County Exhibit number 4. Would you please pull that up? And then keep drilling this down a little bit to try and get us all on the same page here. Thank you. If you could just, thank you. So this is an aerial view of the Sacramento County ambient noise level measurement sites. It's prepared by me using the latitudes and longitudes provided in AHO 1187 for these sites, using Google Earth and Microsoft Word, nothing too fancy. The yellow dots represent the locations of these two measurement sites, M01A and M01B. Mr. Volk, does this look accurate enough to you?
Objection, lacks foundation. I mean, there's no evidence in the record. What I know, she's representing that she did that, but we can't know for sure. And there are maps already provided in the testimony.
Well, there's not a map that shows these. That's why I had to create it. I couldn't find a map that shows these sites at this level of specificity, and it's relevant to this line of questioning.
Let me ask this way. I mean, Mr. Volk, based on your knowledge and the documents we've just looked at, are you able to have an opinion about the accuracy of these locations?
I mean, they seem reasonable to me.
Okay.
Yeah. I mean, like I said, I accept that you represented them. That comports with my recollection of where they're located generally. Yeah.
Okay, great. Thank you. Thank you, Mr. Volk. Appreciate
I would
that.
just put a standing objection on the record that this lacks foundation. I know the questions are going to proceed, but that Mr. Volk has not testified that these are the exact locations, and he's moving forward answering questions based on the representation of that this was created accurately.
Understood that these can be located in Appendix 24D as well. I was just trying to make it easier on everyone here. If I can proceed.
Thank you, Ms. Morris. Understood. The objections noted, and please proceed.
So, Mr. Volk, not to belabor this point, but to confirm, the ambient noise measurements taken at these two locations were used in some manner when analyzing project construction noise impacts in the EIR, correct? They were involved in the analysis.
Yes, we did use them we did use them in informing the thresholds used to determine impacts. Yes.
Thank you. And in your testimony on page 4, lines 13 to 14, and I don't know if you want to return to that or not, you classify the average daytime ambient sound level as, quote, what one might expect for a quiet urban setting, end quote. Is that correct? Is that accurate?
Yes. Well, 52 decibels is consistent with a quiet urban setting as we reviewed in the table that's in my testimony. And yes, 50 decibels is consistent with that type of setting. Yes.
Got it. And although you only expressly discussed these two Sacramento County measurement sites in your testimony, Did you intend this conclusion to apply to the entirety of the DCP study area? This quiet urban setting conclusion.
A quiet urban setting. Well, my testimony is really focused on the community of Hood, so I don't want to characterize the entire Delta conveyance based on my testimony, which was really focused on the community of Hood and the intakes.
Okay, so would you say that this applies, this conclusion about the quiet urban setting, would you apply this to the entirety of Sacramento County, or are you just, even though it doesn't state this in your testimony, are you confining it to the community of Hood?
Well, my testimony is based on the community of Hood and the area around the intakes. So because that is the scope of my testimony, I would say that it is meant to characterize it that way. Yes.
Okay. Okay. So, Ms. Mullen, would you please return to AHO 1183, please, PDF page 9. Thank you. Thank you. Lines 5 to 6. There we go. Thank you. Right there, it says that much of the study area consists of open space, which is typically a quiet rural setting. Do you see that description, Mr. Volk?
Yes.
Okay. And now, Ms. Mullen, would you please bring up AHO 1235, PDF page 287? Thank you. Thanks. You might want to. Oh yeah, great. If you want to zoom in on the response there a little bit. This is in the DCP final EIR response to comment table 4-3, responding to comment number 523-54 from Sacramento County regarding the EIR's noise analysis. Mr. Volk, are you familiar with this material at all?
Yes, I prepared the responses to the comments.
Okay, great. And it says in this response toward the end of the first partial paragraph that DWR describes the study area as having rural character. Do you see that? Obviously, you see that terminology. He wrote it.
Mm-hmm. Yes, we do reference that in the EIR, and I think we do basically describe the area as having a rural characteristic, despite the fact that the sound levels that we measured were like that of a quiet urban setting, as we were talking about. So right. Even though it's rural, we characterize it as rural, even though there are noise sources that are consistent with more of a quiet urban setting.
Okay, and that's based on the ambient measurement sites that were located just outside or near the town of Hood, correct?
I don't really understand the question.
Well, you classified that region as, you made the conclusion that when the noise levels, the ambient noise levels are what one might expect for a quiet urban setting based on the measurements taken at those two sites next to the town of Hood, correct?
That's correct, yes.
Okay. So the intake locations that are nearby the town of Hood, to the north of it and to the south of it, would you characterize the area around those intake locations to be rural or urban?
Objection relevance. Seems to be a confusion between how one describes the area and how Mr. Volk was describing noise, and he just stated the answer to this question.
Well, I'm sorry.
Go ahead.
I'm asking about the intake locations that aren't in the town of Hood, they're outside the town of Hood. Would you characterize the area around those, understanding the definitions we're using here and the noise charts and all of that? Would you consider the areas immediately surrounding the proposed intake or the approved intake locations as rural or urban?
Well, as we describe in the EIR, we're generally characterizing the Delta as a rural setting, and that would include the intakes. And I think we're basically saying that we're accepting it as a rural setting, even though we measure sound levels that are more consistent with a quiet urban setting. So, so we're basically conceding that there is a rural characteristic to the area, and so we account for that.
Understood. Thank you. And if I'm wording this question awkwardly, please let me know and I'll try and reword it. Mr. Volk, could taking ambient noise measurements near a more developed community like the town of Hood result in noise levels that appear higher than those taken in a more rural and less developed setting?
Objection, incomplete hypothetical.
Should I rephrase?
Please.
Okay. Mr. Volk, is it possible that noise level measurements would be higher is it possible that your noise measurements near the town of Hood were higher than had they been taken further away from the town of Hood? Further into the agricultural areas surrounding Hood?
I mean, it depends. There is traffic present. There are other noise sources present. As I indicated, there are a number of noise sources, as I indicated in my testimony, several different categories of sources. Well, we could just bring up my testimony, DWR 700. I believe it's page 2 or 3. It is, yeah, 3, page 3 of DWR 700. So in this portion of my testimony, I describe the practice to determine noise impacts, which includes measuring ambient sound levels. And so there are existing sources of noise at the Delta, and among those were traffic sources such as Hood Franklin Road, which is the nearest road to measurement sites in Hood, but there are other sources present. There are other roads, there are aircraft, agricultural equipment, and other categories of sources. So, I mean, I will say that the monitoring in Hood was not really an outlier compared to the other sites that we sampled around the Delta Conveyance. We sampled 14 sites total, and there was not, I would say that they were all within, I can't remember exactly what the range is, but within about 10 to 15 decibels, I think, during the day, something in that range. I mean, we could.
So just to ask a question off of that testimony. So you're saying that measurements taken further outside the town of Hood, outside of Sacramento County, obviously, because those were the only 2 sites where measurements were taken inside Sacramento County, came within 10 to 15 decibels of measurements taken in the town of Hood. And could that be above or below those measurements?
I would state it another way. I would just say that the measurements in Hood they fell within the range of other measurements that were collected, and I wouldn't consider them outliers compared to what we collected elsewhere.
Okay, so some were above, some were below. Is that safe to say?
Within the range, yeah.
Okay. Just real quick to circle back, sorry to do this to you, Ms. Mullen. Could you please pull up AHO-1021? This is an EIR map. And that would be PDF page 3. Thanks. So this is the map, the EIR, DCP EIR map that shows the town of Hood. Doesn't show the measurement sites, but it shows Hood, and then it shows the intakes. This is for the Bethany alignment. It shows the proposed intakes, one above north of Hood and one south of Hood. Intake C. Could you approximate how far intake C is from the town of Hood, if you had to, Mr. Volk? Feet or miles?
Objection calls for speculation.
Okay.
Lacks foundation. There doesn't appear to be any marker of distance, at least shown on the screen.
Okay. So, but it's south of Hood. We can see it's separated from the town of Hood by agricultural land, correct?
Though would be among the land uses between intake C and Hood. I think
Okay.
I'll accept your representation that that's the case.
Okay. So intake C, for example, it is immediately surrounded by rural uses, correct? Could you characterize it that way?
Yes, there are rural uses adjacent to intake C.
Okay, thank you. And then just to confirm, part of the EIR's analysis of construction noise impacts included comparing the increase in noise levels during construction to the baseline ambient noise levels established by DWR, correct?
That's correct.
Okay, thank you. I'm done with this image, Ms. Mullen, thank you. I just want to really quick nail down some information in your testimony about the average ambient dBA. Ms. Mullen, would you please return to Mr. Volk's testimony, page 4, line 13? Great. There you say based on a measured sound level of 52 dBA. And that represents the average daytime ambient sound level, correct?
That is, yes, that's what we measured at the 2 sites in Hood. That was the average between the 2 sites.
Okay, got it.
In terms of I'm sorry, in terms of a 1 hour average sound level, as I state in my testimony, yes.
Okay, and then on lines on page 5, if you could go to page 5, Ms. Mullen, lines 8 to 9. You state that it looks like you're stating that the ambient noise level for the Delta would be about 50 dBA during the day, correct? That's the average for the entire Delta?
Yes, that's what it says.
Okay. Great, thank you. Ms. Mullen, would you please scroll to page 7 of Mr. Volk's testimony, lines 11 to 13? Thank you. You state in your testimony here that construction noise is temporary, albeit lengthy, and that it may result in community annoyance in some situations, quote unquote. Is that correct?
That's correct.
Okay. And then on page 11, paragraph 28, you state that the long-term use of heavy equipment is estimated to occur for up to 12 years, correct? If we can scroll there if you need to take a look.
Yes, well, to clarify that what it says is that the long-term phase of construction, which is absent pile driving. So it's the use of heavy equipment for the build-out would take 12 years. And
Gotcha.
yes, equipment noise would potentially exceed 60 decibels, 1 hour LEQ during the day at 9 residences, according to worst case modeling. So
Okay.
that's during the day. Yeah.
Got it. And Ms. Mullen, would you please return to AHO 1183, please, PDF page 1? Thank you. Lines 15 to 16. And if it makes it easier, I think you could close out the other tabs that were used for Ms. Tabor's line of questions. I won't be using those. Thank you. So here, lines 15 to 16, the EIR states that DCP construction is anticipated to occur over a duration of approximately 12 to 14 years, accounting for all features. Is that what you're seeing there, Mr. Volk?
That is what it says. That's accounting for the entire project from beginning to end.
Okay,
All features.
Okay, so then, but you testify that it will only last up to 12 years. Can you explain the discrepancy between what the EIR says and what your testimony says? I know that you said pile driving doesn't account for pile driving, but will pile driving be occurring an extra 2 years? Is that what we're talking about here?
Objection misstates testimony.
Well, then let me re-ask.
Go ahead. Thank you.
So, okay, let me just ask this. Why do you testify that construction activity will last up to only 12 years when the EIR states it can last up to 14?
I believe 14 years was under one of the alternatives. I don't recall which one because lately we've been focused on the Bethany alternative. Possibly it was one of the 7,500 CFS alternatives. But that's just my vague recollection.
Okay.
Yeah.
Okay, so you don't know whether or not the approved alternative could last, construction on that alternative could last up to 14 years. You're not sure.
Objection misstates testimony.
That's why I'm asking a follow-up question.
Yeah, that's fine. Go ahead, Mr. Volk.
My understanding is that the Bethany alternative would take 12 years, but I'd like to ask Glenn Buchholz to confirm that information.
Thank you.
The majority of the construction up to 12 years, we have a 2-year commissioning at the end of that construction period where there's some cleanup construction, but most of it's testing the facilities, and especially for the intakes near Hood, because we have a lot of fish and wildlife permit requirements that we'll need to work through over 2 years. So there'll be staff on site, but it's not, there's the large percentage of the construction will be complete by that time.
So in that final 2-year period between year 12 and year 14, Ms. Buchholz, you're saying there could be some cleanup?
There'll be some cleanup of grading, and there'll be some things. I won't tell you there won't be any earthwork, but it's primarily to clean up the site, put the final fencing up.
Could that clean up?
Majority of the work will be commissioning the intakes.
But could that clean up in that final 2-year period between years 12 and 14? It sounds like it could include equipment, trucks, things of that nature. You mentioned grading. Is it possible that noise generating equipment is utilized in the final 2 years?
Trying to remember when the restoration of the site is. The site restoration would be before the last 2 years. So I think this is primarily commissioning during those last 2 years.
So I'm sorry, not to beleaguer. You say it's
primarily. No, I made it sound more confusing than it should be.
Okay, so no construction, no equipment will be used in areas of construction in those final 2 years.
No major earthwork. There may be minor things to put up the final fencing or signs or things like that.
Okay. I don't feel like my question was answered about
we don't have the full schedule out there, but in the EIR and the EPRs we used the schedule that showed that the major earthwork, including the restoration of the land, would occur before those final 2 years.
Okay, but you just said you don't have the full schedule, so it sounds like it's somewhat indeterminate
It'll
whether
be
or not those
determined
last 2
during,
years.
it'll be completed during design. We'll know
Okay.
more details.
Okay, so we don't know now. Got it. Thank you. Okay. Trying to cross off things that I don't need to ask anymore. Okay, so Ms. Mullen, I'm sorry, would you please bring back up Mr. Volk's testimony, page 6, lines 6 to 7? Thank you.
And I'm anticipating Ms. Carroll's question. Ms. Shorrock, do you have an estimate of how much time you have left on your questioning?
Gosh, I'd like to say a half an hour to 45, but it just depends on how the answers go. These answers are more robust than I was expecting.
Understood.
So-
And let's pause here. I think I'm going to take a break, but let me turn. Ms. Carroll, it looks like I accurately anticipated your question. So I think
Yes, you did.
let's go ahead and take a 10-minute break. We'll come back at 2:47 and we will pick up again.
Sounds great. Thank you.
All right.
It is 2:47. We are back. I will look to our court reporter. Are you ready for us to go back on the record?
Yes, we're ready to go.
Thank you. And I see we have our witnesses. We have Ms. Carroll and we have Ms. Shorrock. So with that, I will hand things back to you, Ms. Shorrock.
Thank you. Ms. Mullen, would you please bring back up Mr. Volk's testimony, page 6, line 6 to 7, please? Thank you. Mr. Volk, here you discussed the Yolo County exemptions for construction noise, correct?
Yes, that's part of my testimony. That's correct.
Okay. Are you aware that Sacramento County exempts construction noise only up to 8 p.m.?
If we could go to that part of my testimony, I believe that is,
Do you know what page
I think
that's on?
I think it's on the same page. Yes, it is.
Okay.
Page, bottom of page 6.
Oh, got it. There's great. Thank you. Just confirming. Okay, I'm going to ask a couple of questions about truck noise. Ms. Mullen, would you please, I think you're on page 9. Oh, go to page 9, line 18 of Mr. Volk's testimony. On page 9, line 18, you mentioned concrete trucks, correct?
Line 18, yes, it's talking about the use of night work for concrete pours, or requiring the use of concrete trucks.
Great. And is this, I believe this is the only place that you mentioned trucks in your testimony? Just this once, is that your understanding?
I believe that's correct.
And do you know, off the top of your head, approximately how large are concrete trucks, the ones that you refer to in your testimony? I think what's the size?
What is the size of a concrete truck is what you're asking me?
Yeah, I mean, just generally, how big is a concrete truck?
Maybe if I just might add, they're usually 10 to 12 cubic yard concrete trucks.
Okay. And then do you know, Mr. Volk or Mr. Murdoch, do you know what approximate noise concrete trucks generate off the top of your head?
Yeah, I'll take that question. Concrete trucks, well, that there is a source level in the Federal Transit Administration manual. I don't believe it's part of the exhibits, though.
Okay.
But it is in the environmental impact report, the AHO 1183. I know we have a data table that lists different source levels for construction equipment, and it is listed in that table.
Okay, great. Thank you.
Yeah.
Speaking of AHO 1183, Ms. Mullen, would you please return to AHO 1183, PDF page 39? Thank you. Let's go to table 24-15, please. If you scroll down a little bit under the heading truck traffic on haul roads. There we go. Thank you. The table 24-15 shows that existing average daily traffic on Lambert Road and Franklin Boulevard would be 557 trips, is 557 trips for each roadway, existing ADT. And it shows that the project would increase that number by adding 490 average daily truck trips on each roadway. Is that correct, Mr. Volk?
That is what it says in the table.
Okay. And do these numbers represent only concrete trucks? That's what the paragraph above indicates, but I just want to confirm.
Okay. Yes, that is, yes. I will say yes. That's
Okay.
correct.
And this amounts to almost a 90% increase in traffic on those two roadways. Does that sound right to you?
Well, the average daily traffic, I believe, accounts for all vehicles using the road. So the haul trucks, they're not all trucks under the existing ADT. The haul trucks would be 490 trucks on
Got
top
it.
of the existing traffic.
Okay, right, got it. So it increases it.
Mm.
Okay, and if you could, Ms. Mullen, scroll to PDF page 40, table 24-16, please. Thank you. There we see the existing daily average traffic on Lawford Road at 27 trips. And it shows that the project would increase that number by adding 70 average daily trips, correct?
Yes, that's what it says.
Okay. And again, these are just concrete trucks. That 70 is just concrete trucks.
Yes, that's correct.
Okay, and then this
may I add something that this table 24-16 is actually for the central alignment, and there should be a table later on for the eastern portion of the alignment, which would be part of Bethany.
Okay, got it. Thank you. But these tables, these traffic noise levels on access road tables, they all only represent concrete. They don't only include ADT additions from concrete trucks, correct?
Objection. I'm unsure. There's a lot of tables in this document, and are we referring just to the one that's shown on the current page or to all the tables in this document?
There's a series of tables discussing traffic noise levels on a variety of access roads. And I'm just confirming that when we're talking about project haul trucks in these tables, that we're talking about concrete trucks. That's what the language indicates throughout the EIR. And I'm just confirming that we're talking about concrete trucks.
That's not what this table says. And I think if you're going to use that assumption, we would need to go through the tables, and I would object as to the relevance if this is not for the Bethany alternative.
Okay. Can we move, Mr. Volk, do you know off the top of your head which of these tables, or maybe Ms. Buchholz, which of these tables refer to the Bethany alternative, and could we move to one of those?
I'm not as familiar with this chapter, but it would have to be several pages down. We'll need to go through all the shafts.
I might be able to find it for you.
Good.
Just one will do it. Thank you. I'm searching now too. Sorry about this.
The haul truck traffic starts on page 62 for Bethany.
Okay.
Oops.
That seems maybe too far.
Uh,
Sorry.
I'm sorry. Maybe I don't have the page right.
Okay. Okay. Well, let me come back to this then. We'll put this on hold. Oh, hold on. Okay, no, I think, do I see one here?
It's
Okay.
actually, it's a few pages
Actually,
up.
No,
up.
thank you, I got it. If we could turn to page 60, PDF page 60, table 24-37, I believe that this applies to the Bethany alignment. So, right, we see that the West House Road existing ADT is 368, project haul trucks ADT is 370. Do you see that, Mr. Volk?
Yes.
And those project haul trucks, I'm going to ask the same question. Up top, we're talking about concrete pours. Do you know, do these project haul trucks, are we just talking about concrete trucks here?
Yeah, well, that would, yes, I believe that's correct because that's the time of construction where you would have the greatest truck activity, and that's what our model focused on, was the worst case for the truck traffic. And so
Okay.
that would be 24-hour concrete pours.
Okay.
So that would be the 370 haul trucks in this case.
Okay. Got it. So, are concrete trucks the only heavy-duty trucks that will be used for construction of project intakes, tunnel shafts, and new facilities? Do you know, Mr.
I'm sorry, there was crosstalk there. No? Okay. There would be dump trucks, there would be other types of heavy trucks, delivery trucks, so it's not limited to concrete trucks. We analyzed truck traffic generally, including all truck traffic, not just concrete trucks.
Okay.
Yeah.
So in the modeling for the noise section of the DCP EIR, you considered all truck traffic, not just concrete pourers, all of these dump trucks, excavation trucks, and trucks, transporting equipment, all of that was considered.
That's correct, yes.
Okay, thank you. Ms. Mullen, would you please return to Mr. Volk's testimony, page 12, paragraph 31? Thank you. Here, Mr. Volk. Oh, I'm sorry. Yeah, paragraph 30. Sorry. Thank you. I'm moving too fast. My brain's working faster than anything else right now, I guess. In your testimony, you mentioned a table that you prepared to assist in the testimony of Rachel Gardner, included as exhibit DWR-714, correct?
That's correct, yes.
Great. Ms. Mullen, would you please pull up exhibit DWR-714? Mr. Volk, this table lists sources of DCP construction related noise in the vicinity of Stone Lakes National Wildlife Refuge, correct?
That's correct.
Okay, and the third row down, the table lists haul trucks during concrete pours, correct? I'm sorry, fourth.
The fourth line, yes.
So, but it doesn't mention, I don't see a mention of the use of other construction related trucks on this table. Am I missing something?
Well, the up to 340 trucks, that's the worst case condition that we modeled for a 24-hour period. As I said, there would be other delivery trucks, dump trucks, other types of trucks that would occur at a lower volume relative to the worst case that we modeled.
Okay.
So
but
it's not
those
that
different. I'm sorry. Sorry, go on.
So it's not that we did not ignore those trucks. We simply wanted to focus on the worst case situation for the purpose of our CEQA analysis. And so the concrete pours represented the worst case due to the 24-hour trip be required during the Tremie pours.
Okay, so let me follow up on that. So you said that the concrete pours, 24-hour concrete pours represent the worst case scenario, and that's why this is discussed. One reason maybe why this is discussed in the EIR. In that worst case scenario that you're talking about, these 24-hour concrete pours, was it considered in this worst case scenario that on top of those concrete pour trucks, there would be additional truck traffic? Like dump trucks and soil hauling trucks?
We used the traffic projections that were developed by DCA as part of the engineering report that included the traffic schedule throughout the project. So that included all types of trucks. It was not limited to only concrete trucks.
Okay, so just to confirm, this worst case scenario that you've been discussing during your testimony that I've been questioning you about, this includes concrete pours, concrete trucks, plus additional truck traffic, non-concrete truck.
Yes. I mean, it's representing the time during the concrete pours where the highest volume occurs, but it doesn't mean that only concrete trucks are represented in that number. It's
Okay.
all the heavy trucks. Yeah.
Got it. Is that, to your knowledge, is that explained anywhere in the noise section of the EIR? Do you delineate that anywhere? The way you just did now, or in some discernible fashion?
Objection relevance?
Do you want me to answer that, Ms. Kinsey?
Overruled. Go ahead, Mr. Volk.
Well, I mean, I think it's as I put it. It's the overall quantity of trucks. We didn't specify we didn't classify the trucks. We really looked at the volume to develop the sound level. So,
but
and
sorry, not to cut you off, but this idea that volume represents not just concrete trucks, but all of the other types of trucks related to and used in construction. Is that explained in the EIR or in any one of the appendices that you're aware of off the top of your head? I know that that's what you consider, that's what you're testifying here to today, but does the EIR explain that? Because it's confusing, that's why I'm asking.
Well, different types of heavy trucks, there are different types of heavy equipment that we accounted for in our model. Those are listed in a table in the EIR, including the noise emissions from each of those equipment types. And so we account for it that way by describing the equipment types that we accounted for in the modeling, and we accounted for the worst case for each of the construction phases.
Right. So, but equipment and trucks aren't the same thing. I mean, equipment is delivered by trucks, but equipment doesn't necessarily mean a truck. They're distinct sources of noise and noise analysis, correct?
Well, sure, but so I mean, certainly we modeled the heavy trucks on in the truck traffic analysis that we were looking at earlier in those the traffic noise tables. So those are modeled in the traffic analysis, whereas the heavy equipment would be occurring within the construction sites. So the heavy truck traffic would be on the roads and in the construction sites, while the heavy equipment would be within the construction sites. Okay,
but again, just trying to get a direct answer here. I don't want to put words in your mouth. That's why I'm continuing to ask this. Let me ask this from another angle. To your knowledge, as one of the authors of this noise section in the EIR, did you explain in the EIR the differences between the different types of trucks that would be used during DCP construction and how those different trucks were considered in the modeling, in the worst case scenario modeling? Because I'm not finding it. So I'm asking you to help me out here and let me know if you know specifically a location in the EIR where this is explained.
Objection, vague and ambiguous as to what phase of construction the witnesses as testified about multiple phases of construction, are we talking about specifically for the concrete pour timeframe or something else?
All of it. I'm talking about any explanation in the EIR that discusses anything other than concrete trucks, or anything other than concrete trucks discussed in the EIR, how that's modeled.
I guess I must not be understanding your question. I mean, I can really just say it this way, which I think I already answered to, is that we have a traffic noise analysis that counts for the worst case of the heavy trucks involved, and that includes the concrete trucks is the worst case from a CEQA perspective, which is the focus of our analysis, to model the worst case to determine where the significant impacts would occur. So
Okay.
because
Thank
the
you.
concrete pours were worst case, that we focused on that. So
Okay, thank you. I'll move on. Thank you.
okay.
I'm going to ask some questions about noise mitigation now. Ms. Volk, would you, I'm sorry, Ms. Mullen, would you please return to Mr. Volk's testimony, page 1, lines 17 to 19, please? Thank you. Thank you. You state here that you participated in development of the EIR's noise mitigation measures, correct?
That's correct.
Okay, so it's accurate to say that you're familiar with mitigation measure MM-NOI-1.
Yes, I'm familiar.
Okay, great. Ms. Mullen, could you please scroll to page 12 of his testimony, lines 7 to 11? And here you discuss the mitigation measure I'm referring to, MM-NOI-1, which consists of 5 primary components. And I'll just list them here so you can confirm them as the author. Pre-construction activities, 1, 2, a sound insulation program, 3, sound level monitoring, 4, best noise control practices, and 5, installation of temporary sound barriers at work areas. Does that sound right?
That broadly describes those categories, yes.
Perfect, thank you. And then on page 12 of your testimony, we're on page 12, lines 8 to 9. We're on page lines 8 to 9, perfect. You discuss the ombudsman requirement, and you characterize it as a requirement of mitigation, MM-NOI-1. But it doesn't appear in that mitigation measure. So are you referring to the project ombudsman discussed in section 3.20 of the final EIR? Is that what you're talking about there?
I'm sorry, can you repeat the question?
Sorry, to compound. You talk about an ombudsman in regards to being a component of mitigation measure NOI-1, but MM-NOI-1 doesn't talk about an ombudsman. That's discussed in the project description. Is that your understanding?
Well, can we go to the environmental impact report?
Yeah, we can. If you want to go to AHO 1183, Miss Mullen, page PDF page 65, that's the mitigation measure. And if you just want to kind of slowly scroll, we can see the different categories that we were just talking about. Pre-construction actions, and then if you keep scrolling, sound insulation, keep scrolling, please. Sound level monitoring, best noise control practices, thank you, keep going. Installation of temporary sound barriers in work areas, keep going, please. That's it. No ombudsman.
No. the ombudsman is listed there, but I think we'd have to go return further up to the top to locate that.
Well, I've done a word search in this file and I've not found the word in the
No.
file. I did find it in the project description, which is what I'm trying to get at. Should we bring up the project description?
No, that's
Okay. If we could bring up AHO 1005, please, PDF page 163.
But hold on for a moment. Mr. Volk, did you have something to add? I know I think you're thinking over there, but I didn't know if you had something else to add to this thought.
Yeah, just in regard to the ombudsman, you made a reference to that, so
I just wanted to make sure before we jumped away from this document that you were.
yeah, if you don't mind, can I take a few minutes? Well, not a few minutes, just a moment to look at this. Yeah, I went back and looked at the mitigation measure NOI1 in the EIR, and I don't find the word ombudsman in the measure, but the intention is that DWR would coordinate these measures, and it does say that. So the DWR coordination would be through an ombudsman.
Okay, yeah. Thank you. If we could just go ahead and pull up AHO 1005, please. Ms. Mullen, PDF page 163. Just so we can have some of the language in front of us. Scroll down to the bottom there. Thank you. I guess keep scrolling. Sorry, I thought it was 163. It might be 164. Yeah. Maybe I'm getting that wrong. Okay, well, we'll move on. I thought that it was the discussion was there. Well, actually, if we could scroll up to section 3.20, maybe I'm just missing it in the wrong direction. Okay, there we go. Okay, right there. Thank you. So this is where I saw that language. Is this kind of what, when you're talking about this concept, is this what you're talking about here?
Well, yes, the coordination through DWR would be through an ombudsman to be to the community and a resource for the different mitigation options described in Chapter 24, mitigation NOI1. Yeah.
Okay, and you're familiar with this ombudsman concept, how this would work?
How this will work? I'm not an expert on that, but it would be coordinated through DWR. That perhaps Gwen Buchholz, could you speak to that at all, or?
Just does anyone on the panel have any familiarity with
this is how it's been presented, both in stakeholder engagement committee and appropriately here in chapter 3 of the EIR. This is still being developed. So more detail will be coming out in the future.
Okay, so to your knowledge, Ms. Buchholz, right now, there's no set time frame in which the ombudsman would be required to respond or to deal with any complaint that might come in. That's a detail that will be worked out later.
At this point, this has to be developed during the design phase so that it's both, so it certainly will be fully implemented by the time construction, if not before.
Okay, and is it your, Ms. Buchholz, is it your opinion? Well, it would appear that this will require voluntary action on the part of members of the public who might complain, that this is a bit of a voluntary measure in that it requires voluntary actions, voluntary complaints. Does that sound accurate to you based on your understanding?
I can't say at this time because the program hasn't been fully defined of how this would handle it. I've seen it happen in different projects in different ways.
But ultimately, it would require some kind of contact from a member of the public to this ombudsman, correct? I mean, that's the general concept, right?
The concept as noted in line 39 of page 3-162 is to reduce a person not knowing who to contact at DWR or DCA and being able to be that one point of contact so that the person would have an issue, they could only call one. They would have to be redirected in any place.
Okay, so if I'm looking at the next page, 163, on lines 1 to 3, it says the ombudsman would be available as a primary point of contact. Then it goes on to say the project ombudsman would answer questions. Members of the public would have to ask those questions, correct? Voluntarily?
At this point in time for this writing, that would be the case. Whether it changes as you keep going through this section, there's additional information down below.
To your knowledge, Ms. Buchholz, will there be a plan, like a formal plan prepared to delineate these details?
My understanding that there would be a plan developed, and that's how it's happened on other projects that I've participated in.
Okay, and would this plan be developed by DWR?
Yes.
Okay, thank you. If we could return to Mr. Volk's testimony, please, Ms. Mullen. Page 12, lines 7 to 8. You mentioned sound level monitoring, which is a component of mitigation measure NOI-1, correct?
That's correct.
Okay, Ms. Mullen, I'm going to be flipping you back and forth here. Sorry about that. If you could return to AHO 1183, PDF page 66, lines 17 to 36. Sorry, that's 1183. Page 66. And then lines 17 to 36. Thank you. It says here that this measure requires sound level monitoring at several locations near construction work areas to verify compliance with applicable noise limits that are outlined in the measure. Is that correct? Is that generally how this works? Mr. Volk?
Well, I'm not sure about your use of the word required, but this is a measure that is available to be used in appropriate situations where construction noise monitoring is desired to understand the extent of noise exposure in a certain community. Okay. That resource is available because there are times where members of the public would like the sound to be directly measured at their residence. So this is a resource that's available as a measure to help inform how other measures may be applied.
Okay.
If I may add something to that, if you don't mind, that there's two factors going on here. One is, will there be sound monitoring around the construction sites, especially the large construction sites? And the answer is yes, because we have environmental commitments in the EIR and that would need to be shown compliance with. What I think that's number one item. Number two item that Mr. Volk just responded to was, could there be residents or landowners who would like to have an additional monitor that could be a voluntary monitor? But there will be construction monitoring at the construction sites, or noise monitoring at the construction sites.
Okay, well, let me ask questions about that second component, Ms. Buchholz, and I think this might be for Mr. Volk, or maybe it's for you. The entity in charge of overseeing all of these monitoring locations, would that be DWR, and would verify exceedances? That would be DWR?
It would be DCA.
DCA, okay. Ms. Mullen, would you? Oh,
but
I
we
see.
report with DWR. We coordinate with DWR, but it would be DCA.
Okay. On lines 19 to 21 on this same page, this measure states that these monitoring locations would be located, quote, as near as possible to a location equidistant from the construction boundary to the nearest sensitive receptor. I'm reading that accurately? You see that language? Equidistant?
That's how the mitigation measure is written, yes.
Okay. Would these equidistant locations always be situated in the same direction as the nearby sensitive receptors? Meaning, if the sensitive receptor was to the west, could the equidistant location be located to the east? Just the same distance, but to the east?
Well, and that would need to be developed. If Mr. Mullen, if you could scroll up to the top of this list, I apologize, but just keep scrolling up to the first one. Keep going. It's on the previous page, I believe. There it is. Stop. It's the first paragraph under the words mitigation measure. So it's line 20, that there would be a noise control plan developed. And in that case, those items would be detailed in that noise control plan.
Okay. So as of now, we don't know whether.
No.
Okay.
It'll depend on each site. When I've done this before, it depends on the site and how it's oriented, etc.
Okay. Well, I don't want to get into an objection about a hypothetical here, but the term equidistant does appear in this measure.
And that would be taken into account in the noise control plan.
Okay, got it. So speaking on this subject of things that could be taken into account in the noise control plan, could sound levels differ between directions? So for residents to the west and an equidistant location were to the east, could the sound levels differ based on factors like wind and topography and things of that nature?
Incomplete hypothetical.
Yeah. Okay. We can move on. Okay, and Ms. Mullen, if you could go back to page 66 of this PDF, lines 25 to 30. Thank you. Okay, so in lines 25 to 30, we discuss what's discussed in the EIR are exceedances that would kind of trigger some type of mitigatory action. It says here that this measure allows construction noise to exceed a limit prescribed by DWR between the hours of 7 a.m. and 10 p.m. for up to 3 days, every 2 weeks, within 14-day period before being considered an exceedance requiring a mitigation action. Is that correct? Am I getting that right? 3 days, 3 days for every 14-day period? Mr. Volk?
What it says is that daytime exceedance would occur if on-site equipment or truck noise during daytime hours is measured to exceed a daily average of 60 decibels for a period of more than 3 days in a 14-day period. Yeah.
Okay. And then, and it says down at the bottom, And would that apply? Nighttime exceedance would occur if on-site equipment or truck noise nighttime hours is measured. Sorry, I'm trying to. So, but for nighttime exceedance, would the exceedance have to occur for more than 3 days as well, or is that just for daytime?
Well, the limit is different. For the daytime, it's 60 decibels, and for the nighttime, it's 50 decibels. But yes, it's 3 days in a 14-day period.
Okay. When crafting this mitigation measure, did you or anyone else consider a zero exceedance measure where any exceedance of any noise limit near a residence would be considered an exceedance in terms of taking additional mitigatory action? Was that at all considered?
A zero exceedance? What do you mean by zero exceedance?
Well, I guess what I mean is, was there ever any consideration that any exceedance, not over the course of 3 days, but at any given time, if it was determined that noise levels exceeded the thresholds included, the standards and thresholds included in the EIR, that this would be considered an exceedance within the definition of this measure that might then trigger the following mitigation action of contacting affected residents and offering relocation assistance?
Well, as I state in my testimony, some noise from construction is to be expected, and the DWR set limit of 60 decibels during the day is equivalent to normal speech at a distance of 6 feet. It's the background level at which you can communicate at that distance.
Mm-hmm.
So to mandate a zero exceedance criteria in that regard would be extremely restrictive and I think unrealistic for possibly even existing in the community of Hood, but certainly any construction situation and or even next to a road. 60 decibels is not a very loud sound level. I mean, you can imagine as I describe it, that having a conversation with a person 6 feet away from you, that's not a very loud situation.
So follow-up question on this. So in this measure, again, daytime average 60 dBA must be exceeded for a period of more than 3 days in any 14-day period. When this measure was being drafted, was there a consideration of a 2 days exceedance or 1 day exceedance? How did you arrive at 3 days exceedance as the number where some mitigatory action might be offered?
Well, 3 days in a 14-day period.
Yes. How did you arrive at that 3-day number?
Well, it's 3 days within a 14-day period, and that's a worst case level. It was just a reasonable determination of what would be what could be considered a daytime exceedance in this context.
Okay, so you just said just now this was considered a worst case level. So you're saying that you set the exceedance level at a worst case level?
Wait, I'm sorry, I'm not understanding. I don't think that is accurate to what I was saying.
Well, you just said when you were considering the 3 days in any 14-day period, you saw that as kind of a worst case, as a worst case level. That was your exact words you just used. So you set this exceedance level at what you consider to be the worst case level.
No. Then if you understood that to be what I said, then I need to rephrase what I said.
Please, thank you.
Okay. So the 3 days in any 14-day period, if it exceeds 60 decibels, which is the DWR set limit, then yes, that would be considered an exceedance. But our modeling considered the worst case. That's what I meant by worst case.
Got it. Thank you. Thank you for clarifying. So again, when you came to this determination 3 days within a 14-day period, I'll ask the question again. Did you consider 2 days, 2 days of exceedances within a 14-day period? Was that considered?
Yes.
And you decided to go with 3 days?
Yes.
Did you consider a 1-day exceedance?
Yes.
Did you consider a 4-day exceedance?
Yes.
Okay, so you settled on a 3-day exceedance. Was this just you? Who else was involved in this discussion on how to set this exceedance period?
This was reviewed extensively by DWR and DCA, and so all parties agreed that this was a reasonable threshold to consider for this mitigation measure.
Do you have the names of particular staff members who were involved in making this final determination that 3 days of an exceedance across a 14-day period should be included in the measure? Do you have any names?
Objection, relevance.
Just trying to understand how this thing was prepared. Thank you.
I don't have all the names, but there was a lot of people at DWR and DCA reviewed this document.
Okay. Okay, thank you. You said that you used the term unrealistic and used the terms unrealistic and extremely restrictive when I was talking about a 0 exceedance when we were discussing that concept. Would you apply those? Would you think that a 2-day exceedance over a 14-day period, would that be considered extremely restrictive or unrealistic in your mind? Your professional opinion?
But I don't know how to answer that.
Okay, well, I mean, you're a noise expert, right? You helped prepare this measure, and I'm just trying to understand where the threshold for something being unrealistic and extremely restrictive lies, because you landed on 3.
Yeah,
so
I
you
landed,
found
yeah.
that to be realistic.
Yeah,
So
well,
where's unrealistic?
Well, this is a proposal that I developed in this mitigation measure, and it was reviewed by DWR and DCA and during public comment. So this is
So somebody else made the final call. Somebody else determined that the 3-day within a 14-day period, that was not considered unrealistic or extremely restrictive. Somebody made that call.
Objection, argumentative.
I think, Ms. Sherrick, if you can move on to your
Yeah.
question. Thank you.
Thank you. Let's move on. Okay, so lines, if you want to scroll down a little bit, Ms. Mullen, to lines 31 to 33 on the same page. Thank you. So the mitigatory action included in this measure would be the relocation assistance for affected residents, correct? That's kind of the action item here in terms of reducing impacts of noise on residents.
Well, that is one option that is available to residents if they desire it.
Okay. So it sounds like what you're saying is that this would be like a voluntary, I mean, the measure says it, but that this would require voluntary participation.
Oh, yes, of course.
Okay. And has a relocation plan been prepared, or will one be prepared?
I'd like to ask Ms. Buchholz in the context of DWR coordination of the mitigation.
There are many things that we're looking at as we look forward to things that have to be done during design, including, as we established at the top of this list on the previous page, I think it's the previous page, where we have to do a noise control plan. Or not have to, we've said we will do a noise control plan. The details for that and more details about developing this, more details on this type of the workflow that would occur to talk with the residents will be prepared in that noise control plan during the design phase.
Okay, thank you. And will this noise control plan be made publicly available? Pardon me.
I believe so, because it would have to talk to the people, eventually would have to be shown to the people who could be participating in this.
Okay. So we don't know right now where residents would be relocated. That would be included in some future plan.
Absolutely not at this point.
We don't know how far from their homes they might be relocated.
No, we don't know any of that. We haven't talked about that.
Okay.
And I've done this on other projects. It has worked, and we do make it up and you develop it for the specific locations.
Okay. Would the plan to your, seeing as how you have experience on other projects doing this, would this portion of the larger noise control plan that discusses relocation, would this be like an active document, a living document? Would it be modified if things don't work? Could it be modified if things don't work? Has that happened in other projects, as you mentioned?
Action calls for speculation.
Right. I'm not going to speak to how this plan will be developed. That would be totally preliminary. This has to be developed in design phase. Each project has been unique based upon its situation.
Okay. So I guess maybe you don't know the answer to this next question, but would this plan be developed prior to construction?
Yes.
Okay. Okay, well, let me skip all these questions then. Save us all some time. Thing is how you don't need details. Okay, one last question on relocation. It was mentioned yesterday during somebody's testimony that resident relocation would be implemented as a program by a contractor. Is that accurate? Am I getting that right? Or did I hear that right? That there'd be a contractor who would implement this relocation?
That appears to be an incorrect statement.
Okay.
What we were talking about on construction contractors was the voluntary program to potentially install new windows or doors or
okay.
other
Got it.
sound
Thank you.
insulation, but not for a contractor to relocate person.
Okay, thank you. Trying to word this without getting an objection. In regards to this larger noise control plan in which this relocation component will be discussed, will this noise control plan undergo its own review for potential environmental impacts? Do you know, associated with relocation of residents?
Objection calls for a legal conclusion, speculative.
Let me rephrase. Ms. Buchholz, Mr. Volk, has there been any discussion behind the scenes as these measures were being prepared that this larger noise control plan would have to undergo additional environmental review? Has that at all been discussed?
We don't have the details of this plan. We don't know. That's never been discussed that I've been aware of.
Okay. Mr. Volk, as a technical expert here, in your professional opinion, is it possible that relocating residents could result in potential environmental impacts of their own?
Objection calls for a legal conclusion.
Calls for impact analysis, but
I'll allow the question. If you have an opinion, Mr. Volk.
Are you talking specifically as regards noise?
Sure. Let's go with that. That's your area of expertise. Could there be noise impacts associated with a relocation component of a plan like this in your professional opinion and experience?
I don't believe so, based on the number of relocations that would be anticipated, which I think would be a very low number, I believe. So it would just be a number of vehicles on the road.
Got it. Okay, thank you. Ms. Mullen, would you please return to Mr. Volk's testimony? Page 1299, please. Thank you. Here you discuss the sound insulation for buildings of impacted residents and businesses. This is part of MMNOI-1, correct?
I'm sorry, I'm going to interrupt you, Ms. Shurik. I see Ms. Morris. Did you have a comment or an objection?
No, I just was sorry. I was waiting because she was pulling up a document for a time check because it's been over 3 hours and I think the estimate was 30 minutes. And so I was just wondering if we should take a break or maybe if we're going to maybe finish up
between
and finish before 4:30, maybe stop early. That I'm just kind of doing a time check.
I think I can finish before 4:30.
And we can, our last break was about an hour ago. Maybe we should go ahead and take just a short 5-minute break, and then try to push to see if we can finish up before 4:30. And I remind everyone there are time limits, so I realize these estimates are estimates, but you are the managers of your own time ultimately. So we'll allow you to use it as you see fit, as long as it's productive. So let's go ahead and take a 5-minute break. We'll come back at 3:49. Yeah, I think I said 3:49, although I didn't write it down, but it looks like we're here. I'll look to the court reporter. Are you ready for us to go back on the record?
Yes, ma'am, ready.
Thank you. And we have Ms. Shorrock and Ms. Carroll and our witnesses, so I will hand things back to you, Ms. Shorrock.
Thank you, and I'll try and shortcut through some stuff. I'll try and prevent flipping back and forth in between too many documents. I want to talk about the sound insulation measures a little bit now, Mr. Volk. According to the EIR, the sound insulation improvements could include the installation of dual pane windows, new doors, and new HVAC systems for qualifying residents, correct?
That is correct.
Okay. And would these insulation improvements also be extended to businesses?
Yes.
Okay. But the measure only discusses, when talking about this, the measure only discusses eligible residences. Should we bring that up? Maybe, Ms. Mullen, if you could bring up AHO 1183 PDF page 66. If you right there, lines 34 to 36, it says to reduce the significance of construction noise, this measure will require voluntary participation of all property owners of residences affected by project-related construction. Oh, I'm sorry. Actually, could you scroll up to lines 1 to 3? I'm looking at the wrong thing. Here we go, right there. The following two categories of residences would be eligible. Is there a reason why businesses were omitted from that list?
You know what, I'm gonna, my previous answer, I think I would like to retract that, because I think the intention of this is really to apply to residences, for doors and windows and HVAC systems.
Thank you.
Yeah.
If you could scroll up a little bit, Ms. Mullen, to the page 65. There, right there. It says DWO will coordinate a program to offer sound insulation to property owners of residences and businesses.
Okay.
So you understand the confusion here.
Yeah, I'm yeah, okay. I beg pardon. Yes. So yes, residences and businesses. It depends on a voluntary program. So in terms of residences and businesses, there's some situations where sound insulation will be acoustically effective and some where it would not be effective. So, I mean, for instance, if it's a business that's quite a large space, that would require, but that where it would be where there's outdoor elements or just a situation where windows and doors would not be effective, then basically we try to achieve a target of at least 5 decibels in an interior space. And so we would have to determine on a case-by-case basis whether sound insulation would be acoustically feasible and what measures would need to be taken.
For both residents and businesses, correct? Just to confirm that.
Yes, for both residences and businesses. But again, it depends on the type of business. So I think that's where the distinction is the type of structure where the business is located. Like if it's like a residential structure versus the warehouse, for instance.
Okay. So like for the other components of this measure, the details of this will be worked out in that larger noise control plan. We don't have too many details on how this would actually be implemented. Is that correct?
Objection misstates testimony.
Okay, well, let me ask directly then. Are there any, well, let me just start asking questions and then we can figure this out together, huh? Who would make the final decision or give final approval on what improvements are made and to which homes or businesses? Is that DWR?
Yes, DWR would coordinate the program and the implementation of mitigation measure NOI 1.
Okay, so if a homeowner insisted that they required new windows, doors, and a new HVAC system, and requested that as a part of this program, could DWR deny that request?
Well, it would be evaluated on a case-by-case basis.
So the answer is yes, they could deny that request?
Yes, well, it depends on the situation. I mean, it really would depend on the noise exposure. And so let me add one thing here, is that these mitigation measures there's the pre-construction actions are a very important element of this, because there is a phase of the mitigation where pile testing would be done to determine the sound levels from pile driving as they would be cited and tested. So the modeling results that are in the EIR would be updated based on the field investigations, including the pile testing. So that's an important element of this.
But that's
program.
not it. That's not explained in the EIR, right? You're just explaining that right now, correct?
No, that is in the EIR.
It's not in this. It's not in the measure. It's not explained in this sound insulation program measure.
It's explained in the pre-construction actions.
Got
it's
it.
The future investigations, test pile sound level monitoring that would involve the updating of the results. And
Okay.
the updating of the results is an important step, because for the environmental impact report, this is to determine if a significant impact would occur, requiring evaluation and mitigation. So
Okay.
we've passed that step. Now we have to kind of hone in on, so what is really the extent of the impact?
Okay.
How would the contours be different based on the as cited pile driving and heavy equipment and what have you that we modeled? How
Okay,
would
but
that be modified?
returning to the language of the measure,
Okay.
what you're describing, the pre-construction actions that you're describing, those aren't, to your knowledge, those are not included in the mitigation monitoring and reporting plan as part of this measure, correct? That's something else in a different part of the EIR, correct?
Objection misstates testimony.
Okay, let me ask directly then. Are those pre-construction actions that you're describing included as part of this measure in the mitigated monitoring and reporting plan approved for the DCP?
That's part of the mitigation monitoring and reporting plan and part of the permit terms.
As part of this measure, as part of the sound insulation measure.
If I may add to that,
Yeah.
it's also part of the project description under field investigation as described in Chapter 3.
Right. So maybe I'm not phrasing this right. Let me rephrase. Is that pre-construction activity, Mr. Volk, that you've been describing, is that linked directly in any part of the MMRP to this sound insulation program measure? Because it sounds like they appear, but maybe in different places. Are they linked in the sound insulation program measure in the MMRP as part of approved mitigation? As a way to
It'd be helpful to move up one page to the NOI where it says pre-construction actions. That might help clarify this question and confusion around it.
It's right there, isn't it?
Yeah.
Yes. If I may, this would be all considered in the noise control plan, because we have by that time the field investigations with the pile driving. But this is more than just pile driving, as you've stated before. It's
Thank you.
also
That's right. That was the
other construction noise, and so this all needs to be included and addressed in the, and it has been anticipated to be addressed in the noise control plan.
Thank you. That was what the first question I asked, but thank you very much. Okay, so again, I'm going to keep going because my original question was objected to. If a homeowner insists that they need some of these sound insulation components, windows, doors, and an HVAC system, and DCP or DWR determines that they don't based on all of its factors, would there be an appeal process? Do we know, would there be an appeal process where the homeowner could appeal that decision?
That type of detail is not developed yet, but that would have
Got
to be
it.
addressed in the noise control plan.
Got it. Thank you. And to clarify, and again, this might be something that has to be ferreted out later on, but with these building modifications, these insulation components, would these be offered by DWR proactively? Or would this be something that would have to be requested by homeowners and business owners?
This is all going to be in the noise control plan because you'd have to identify the eligible properties, and we're not sure how that eligibility will be identified at this point in time.
Okay. And then the EIR states that this measure also requires voluntary participation. Is that correct? There would have to be voluntary participation as part of this measure?
Yeah, as part of the sound insulation, voluntary participation is required because DWR and its designates would have to enter the property and enter the actual residence to inspect the windows and doors and determine the feasibility of sound insulation.
So it sounds like there are some known details, because now you're saying to me, Mr. Volk, that DWR would be the one to enter the homes of residents. Is that what you just said? Please correct me if I'm getting that wrong.
Well, DWR, it's designated it's representatives of DWR to inspect each residence that of interest, and then, of course, if they decide to move forward with sound insulation measures, a contractor will have to modify the home. So yes,
Right.
we would need voluntary participation in those types of activities.
Okay, and this might be something for a future determination, but I'll just ask it because I'm unclear now what details are known and which aren't known. Would homeowners be required to sign any indemnification agreements for equipment or other materials that were installed in their house as a part of this program?
That would all have to be identified very specifically in the noise control plan.
Okay, got it. Thank you. Moving on to the sound barrier mitigation measure. This measure is discussed in the EIR AHO 1183 PDF page 67. If you just want to head there, Ms. Mullen, that'd be great. Toward the bottom of page 67. The EIR in this mitigation measure, from what I can see, does not describe the materials that might be used for these sound barriers. Is that correct, Mr. Volk, that this description of materials used for sound barriers does not exist inside this measure here?
That's correct. We don't talk about the materials that would be used, but in general, it would be temporary sound barriers that are used on construction sites for this purpose.
Okay, and just to confirm, the measure doesn't describe or define the height or thickness of these barriers, or it doesn't include any other dimensions of these barriers, correct?
No, it doesn't include barrier designs. That would be a design phase, and also they would need to be cited appropriately where required, where there's a high concentration of work and where there's a high potential for exceedance of the DWR set limits.
Okay, and would this be a measure that, a mitigation measure, a component that would also be included in the noise control, the future noise control plan?
Yes.
Okay, details would be included there. Okay, thank you. And that future noise control plan, that will be prepared by DWR?
DWR would be responsible for its preparation.
Okay, and then, so it would be, I guess, based on evidence probably, but DWR's discretion to determine the type and size of sand barriers that might be used? Mr. Volk?
Let me just add that in my experience, those are usually developed by some modeling as we go through the design, and additional noise modeling is handled. This also will be on it, just would be added because this chapter is respective to land uses. We would also combine that if necessary with terrestrial resources that we have in chapter 13.
Okay,
There
thank you.
are noise barriers for some terrestrial resources. So all this would be combined into the noise control plan on a site-by-site basis.
And Ms. Buchholz, you mentioned your experience with these kinds of plans several times. In your experience, your professional experience, do these plans often or even sometimes include provisions for third-party verification? Meaning a third party comes in and verifies all of these things like dimensions and measurements and things of that nature for sound barriers? Is that something you've seen in the past?
I've had that. I've had that handled mostly by the people who are concerned about it. So it's an open process for the design.
Got it. Okay, thank you. Mr. Volk or Ms. Buchholz, in your professional opinion, do you think that any of these sound barriers could be visible to residents or businesses?
Yes, I think that's certainly a possibility.
Okay, and maybe by boats on the river, do you think that these sound barriers could be visible, some of them by boats on the river? Is that possible?
It's going to depend on where the model shows we need to put it.
Okay.
And put it in with the intake sites are quite large, and there could be intermediate noise barriers that may or may not be visible off-site of the construction site.
Okay, thank you. When developing these noise mitigation measures, some of them involve components that are voluntary, that require voluntary actions. We've gone over that in this line of questioning. Was there ever any consideration of additional mandatory mitigation, like limiting construction near residences to traditional business hours and days, or Monday through Friday on weekdays only? In the process of development, or more mandatory components considered?
As we've previously described in this panel, that construction is limited to Monday through Friday, basically 7 a.m. to 7 p.m., except for the trimmy pours and that would be close to the community of Hood, and then the tunnel boring machines at Twin Cities Complex and at Lower Roberts Island.
Right. Okay. So I have a question about that, but I want to ask that later. Let me just simplify the question. Did the body of people developing these measures and ultimately approving them for inclusion in the EIR consider additional mandatory mitigation versus voluntary for limiting construction noise?
Well, the use of the word voluntary is very specific in regards to this mitigation measure. It's related to voluntary participation of residents. It's not that is the only context where voluntary is used. There are the options here are all available as permit as part of the permit term as options to mitigate and they would be applied as necessary. um, depending on the situation.
Okay. To your recollection, Mr. Volk, was there ever a mitigation measure considered to stop work, to stop construction work if one or more complaints was received by nearby residents? Was that ever considered as mitigation?
No, that is not one of the mitigation measures.
But was it considered in the discussion of preparing measures?
It was discussed.
Okay. And ultimately it was not concluded, correct, or included, correct?
That's correct.
Okay, thank you. Okay. Moving on to noise and health impacts. Mr. Volk, you don't discuss noise-related impacts to human health and welfare in your testimony, correct? You do not discuss that.
Well, let's think about this. I don't specifically talk about, well, it depends on the health effects you're referring to. I think the one that I I guess I reference a little bit is speech interference, which isn't exactly a health effect, but so I guess if you could be more specific that with your question, please.
I think that answer. I think that's an answer for me.
Okay.
You reference in your testimony exhibit DWR-704, correct?
Yes, I do.
And Ms. Mullen, would you please pull that up? Exhibit DWR-704. Oh, great. So this is an EPA document prepared by the US EPA, correct, Mr. Volk?
Correct.
Entitled Information on Levels of Environmental Noise Requisite to Protect Public Health and Welfare with an Adequate Margin of Safety. Is that what you're reading right in front of you there?
That's correct.
Okay. Could you please scroll to PDF page 9, please, Ms. Mullen, of this exhibit? Thank you. And if you scroll down just a little bit to put that number 2 kind of toward the top of the page. Thank you. List item 2 here, the EPA discusses damage that can be done to hearing by noise. Do you see that?
Yes.
They talk about hearing loss or changes in hearing level, hearing impairment. Okay, great. And then if you could scroll down a little bit more to item number 4, Ms. Mullen, thank you. Here they talk about annoyance due to noise and speech interference, correct?
Yeah, it's activity interference.
Got it.
Yeah.
Could you go on to PDF page 14, please, Ms. Mullen? 4th paragraph on that page. There we go. Perfect. Right here, it says the EPA defines the phrase health and welfare regarding noise to mean complete physical, mental, and social well-being, not merely the absence of disease and infirmity, correct?
Correct.
Okay. And then they go on to state that the definition would, quote, take into account subclinical and subjective responses, e.g. annoyance and other adverse psychological reactions, correct?
That's correct.
Okay. And then the next paragraph, the EPA states that the phrase health and welfare also includes, quote, personal comfort and well-being and the absence of mental anguish and annoyance, correct?
That's correct.
To your knowledge, Mr. Volk, does the EIR discuss any of these types of human health and welfare impacts associated with construction noise, DCP construction noise?
We do talk about health effects in a general way in the environmental impact report, yes.
In the noise section?
In the noise chapter.
Can you? Oh, okay, I see. Thank you. But you don't analyze it. You talk about it generally, but there's no impact analysis. It's not included as an impact, correct? As a potential impact.
Well, it's implicit in the impact analysis. I mean, the entire impact analysis is based around the notion that noise causes effects at a certain level, and so the impact is inclusive of the notion that there is an effect on annoyance, on health, and all those factors. That is wrapped up in the thresholds that we use here, and it's implicit in general plan thresholds, for instance.
Okay, so is there, to your understanding, in any of the impact analysis in the noise section, do you discuss disease associated with, do you expressly discuss diseases that might be associated with noise?
We don't go into specific diseases, but I mean, the thresholds are based on health and welfare considerations that are inclusive of any factors related to noise and impacts on health and welfare. So the thresholds account for health and welfare concerns.
Okay, so just to confirm, it's your testimony that the thresholds used in the noise impact analysis for the DCPEIR take into account health and welfare issues, including diseases, hearing loss, mental health, psychological reactions, all of these things that are discussed here by the EPA, that you would say that those are all wrapped up into the thresholds, those underlie the thresholds in some form or fashion?
Yes, well, I mean, I'll just say, as concerns hearing loss is the threshold for that is more directly addressed with OSHA standards in the workplace, where 90 decibels for 8-hour exposure is considered to begin to result in permanent hearing loss. So hearing loss is not really a concern as regards the thresholds that we use in the EIR, but in terms of health and welfare, so I only say that because it's in a bit of a different category, because damage to hearing is from acute sound energy events, whereas health and welfare is more it is in the category of the DWR set limit. I'll just put it that way.
So when the EIR makes a significant and unavoidable impact conclusion related to construction noise, that means that there will be significant and unavoidable impacts on health and welfare associated with noise. Correct?
Objection states testimony.
Okay, so should I rephrase?
Yes, please.
Okay, so does the significant and unavoidable conclusion made in the EIR related to construction noise impacts encompass or include impacts associated with health and welfare?
It does encompass and include those types of effects, yes, using our threshold of 60 decibels during the day, which is a conservative threshold. And as I state in my testimony, considering the sound levels that we expect to occur at residences during the pile driving phase and the heavy equipment phase, we don't anticipate that it would interfere with daily activities. So
okay. So let me ask this another way to try and get at an answer. Does the EIR then consider that construction noise will result, does the EIR conclude that construction noise will result in a significant and unavoidable impact on health and welfare? You can just yes or no me on this one. If
Well,
you'd like.
It's a significant and unavoidable impact because it exceeds the DWR set limit, which was, and noise limits are take into account health and welfare, but it does not necessarily mean that an exceedance of 60 decibels is going to be bad for your health.
Okay, so it's not, it may not be a significant and unavoidable impact when it comes to impacts to human health then. Is that, am I misphrasing that?
Well, all that the analysis says is that 60 decibels is the limit we used. We account for health and welfare in general to people in setting thresholds because noise is associated with annoyance and other effects that we're talking about here. But to link a noise exceedance directly to unavoidable impacts on health and welfare, I think is just, I can't accept that as you presented it here. I don't think you can link them that directly, but
it's not. So when you, let me follow up. So when you wrote this section and when you wrote these impact conclusions, you did not intend that significant and unavoidable impact conclusion to apply necessarily to health and welfare.
Objection, asked and answered, misstates testimony.
I mean, I've asked, but I don't know that it's been answered.
I think you're trying to get to the bottom. Go ahead, Mr. Volk.
The significant and unavoidable impact is in regard to the sound level limits. It's a number that we're using to represent the community.
Okay, got it. Thank you. I know we don't have much time left. I'm going to try and blow through some things here. Mr. Volk, yesterday you stated in your testimony that long-term construction noise, that project's long-term construction noise would not interfere with people's everyday lives. I think that's a direct quote. Am I getting that right though? But that is a direct quote.
That's what it says in my testimony.
Okay. And then you testified that DWR set noise thresholds that were, quote, reasonable and appropriate for communities in the Delta, correct? And you state that in your testimony as well. Okay.
Yeah.
And then you've been talking about the 60 dBA standard equivalent of a person speaking 6 feet away. Can you just really briefly explain to me what makes the 60 dBA threshold reasonable and appropriate for the rural communities in the Delta?
Asked and answered.
I think we've been through this. It was a couple hours ago, but I think we went.
Okay. Let me move on then. Ms. Buchholz, earlier today, you stated previously that EIR language, that there's language in the EIR that limits most surface construction to sunrise and sunset, and that this language appears in mitigation in the biological resources section, correct?
No, I said that in the project description, we talked about sunrise to sunset. There are further limitations in chapter 13 of terrestrial resources that limits it to 7 a.m. to 7 p.m.
Okay, so if I can just follow up.
In some cases, more so than that.
My interpretation of the language in the project description, it applies only to pile driving, but you're saying that it applies to all surface construction?
It applies to all surfaces, as we showed as we went back to the tables in the back of the, it's part of the project description. So it's not a mitigation measure. It's part of the project description that was
So
used
just
for
to
the impact analysis.
got it. So just to confirm,
Hearing
the
officer
7
has been
a.m.
asked and answered.
Let's just get it straight. It sounds like there's a confusion one last time. And then this probably be your last question for the day, if you would please.
Just, yes, this is it. Just to confirm, the 7 a.m. to 7 p.m. limitation that you are stating exists in the project description applies to all aspects of surface construction, not just pile driving, correct?
Except for trimmy concrete pours and tunnel boring machines. Yes.
Okay. And then you also referenced additional constraints in the biological resources section, correct?
Yes, that's so we in some portions of the project description, it talks about sunrise to sunset. Sometimes
Yes.
it's 7 a.m. to 7 p.m. The most stringent will apply.
Okay. Is the word stringent used in the project description that you're aware of?
It is as we move towards some of the EIR terrestrial resource impacts and mitigations.
So it's used in
I think
the biological.
let's pause here. It's 4:26. It sounds like you will have a few more questions for the morning of April 14th. Is that accurate, Ms. Shurak?
I think I might have like 2 more. Yeah, literally like 2 more.
We will hold it until then. Ms. Carroll, did you have anything to add other than we're coming to a halt for the day?
No, that was it. I was just making sure we hit that 4:30 for our witnesses flight. Thank you very much.
Yes, thank you. Before we break in the next 3 minutes, is there anything, well, I will comment, I think we will reconvene on April 14th at 9 o'clock. Hopefully that will in fact be a short day. I think hopefully we can have a discussion at that time. I'm going to look, kind of do time estimates and see where we are with respect to witnesses and estimates going forward to see if we need to add additional hearing days. I don't know that we'll come to a conclusion on Monday, but I did want to give you a warning that we may need to talk about that. But is there, let's see, I see one hand very quickly. Ms. Desjardins. Comment.
I'm wondering if there's any way, I didn't take specific notes on Appendix A to which part of the WaterFix EIR had the participants for the intake selection, and that would be helpful for my cross.
You may be
I don't know if there's a way to to go back.
I don't know if it was mentioned in the Zoom transcript, but that would be, we'll try to get that posted as quickly as possible.
Okay, thank you very much.
Thank you. And then Mr. Keeling, I see you have a hand. If we can please give Mr. Keeling audio powers. Thank you.
I'm glad to be unmuted finally. Hearing Officer Kinsey, just a heads up. Based on the questions I have not heard over the last couple of days, I may have 10 to 15 minutes on Monday. Just a heads up.
Thank you very much. I appreciate that. All right, with that, it is 4:29. We will hold to our hard stop. Thank you for today, and thank you to the witnesses for bearing with us, and I will see you on Monday at 9 o'clock. We are adjourned.